This is the Utah Land Use Institute, and we're doing a seminar on Utah land use and the law related to it. We hope it's enjoyable. The idea is to just do kind of a general outline of what the rules are. What are the ground rules? Where are the guardrails when it comes to local government's decisions with land use in Utah? We appreciate the Office of the Property Rights Ombudsman. They have appropriated a grant for this, and it comes from the 1% surcharge on all building permits in the state of Utah. And without that, we certainly couldn't do it. We couldn't provide this seminar, and so we're glad to have that here. We also appreciate the generous support of the S.J. and Jesse E. Quinney Foundation, which has been our great supporter of the Utah Land Use Institute for some time, and we certainly couldn't function without the great contribution they make. We are also co-sponsored by the Utah League of Cities and Towns, the Utah chapter of the American Planning Association, the Salt Lake Board of Realtors, the Home Builders of Utah, and the Real Property section of the Utah State Bar. So thanks to all those folks. And we appreciate those who take the time to review this. I guess the first thing to do is introduce ourselves. My name is Craig Call, and I'm the Executive Director of the Utah Land Use Institute. I'm an attorney and have been kind of knocking around the land use arena in Utah for probably way too long. With me this morning, those who will be chiming in and offering some color commentary and their own insights are Wilf Sommerkorn, who I have styled as the Dean of Utah Planners. He's been around for a while, and he's a very gifted and talented, articulate spokesman for the point of view of the planners and also of the public in general, because he's been a local planner. He was the planner for the smaller cities in Davis County as well as for Davis County, then became the planning director of our largest city, Salt Lake City, and then the director of regional and transportation planning for Salt Lake County. So he's really had some great experience. Our third panelist is Jordan Cullimore. Jordan is the Property Rights Ombudsman for the state of Utah, and he is an attorney as well as a planner. So he's been with the office 6 or 7 years. He's now the lead attorney there, has authored advisory opinions and assisted hundreds of people in trying to resolve land use disputes. So we are, of course, very grateful that Jordan could join us as well. We will be quoting extensively today from this book, Ground Rules, published just last November. It's available at Amazon.com for anyone who would like to have it. And we are pleased to announce a grant from the Ombudsman's Office that will allow us to provide free copies of this book to members of planning commissions and city councils around the state. So that effort is ongoing. We hope to have those out in a few months and hope that it provides a good basic understanding of how to get your hands around the concepts of Utah land use law. So to get started, when our cities were founded in Utah, there weren't that many people, and we really didn't have much need for zoning law. The couple of Europeans who might have lived in one of our valleys could pretty well handle their own land use issues without a lot of interference. Then more people came, and of course more people came, and then a whole lot of people came. And by this time, the decision was made that we needed to create some kind of organization. So we created local government. Of course, the territorial and the state government came first, and that's kind of the center point. That's where the local power flows, is from the state government, from the state legislature and the Utah State Constitution. But we decided we didn't want all those people making all the decisions, so we selected a few of them, usually 5 or 7, and we put them in a city council. That's called a representative democracy. So then the city council meets, and that's who makes land use decisions. At least that's who sets the policy. They are the ones who write the rules and pass the legislation. And when they do land use issues, of course, they always say yes and everything's fine. No problems, no issues. Life is calm and easy. Except sometimes all those people show up again. And then we have reasons for dispute. And when we have disputes, then we have to resolve them somehow. And we turn to a few authorities that kind of provide, again, the guidelines, the guardrails that limit local discretion in land use. And when we go to court or otherwise try to figure out how to resolve matters, we usually refer to the basic ground rules, the laws that govern the land use regulation process in Utah. Because sometimes when all those people show up, then the council splits, we have no votes and yes votes, and then we have land use disputes. So to resolve those disputes, we look at some basic limits on local discretion. First of all, the Bill of Rights doesn't often come into play in land use decisions, but it's certainly paramount when it is triggered. We have federal statutes and state statutes. We do case law, that is the decisions that are made by our Court of Appeals and our Utah Supreme Court. Local ordinances play into the whole process. Obviously, after the city council has adopted a local ordinance, even the city council has to follow it. And then the codes and regulations, the building code, the fire code, the health code, all those come into play. And that sounds like a lot, but really, there's a lot of local discretion, and we'll talk about it in ways that will probably surprise some who view this, that there is so much local discretion, and then in some ways surprise us that there are limits on it in ways we didn't understand before. So we're just going to kind of get the general lay of the land, how this works, and where the courts and the legislature have tried to draw some guidelines to protect the interests of everybody. So this is our agenda for today. We want to talk about legislative acts generally. These are broad issues of public policy. Then we want to talk about administrative acts, where we're basically applying the code that's already written to our applications that come in. In order to do that, we'll get a little bit into conditional use applications and nonconformities, that is grandfathered uses. We'll also talk about conditions and exactions on development. And then we'll talk about how to make appeals, what the variance process looks like, and how that all fits into it. If we have time, we'll want to cover some land use ethics and best practices, mainly due process, and certainly hope that will work out well for all of us here. So there's more than one person in the land use arena. Wilf, could I invite you to kind of talk about who's involved and who makes the decision and how this all comes about in Utah?
Sure. Whenever we're talking about land use, of course, the main player is the property owner, the person who has the land and who wants to do something with that land. And generally people feel like, and they are allowed to do pretty much whatever they like to with the property that they own. Except that when that property is in a community, it oftentimes then becomes subject to those pesky land use regulations. And those land use regulations are put in place by the officials of the community in which that property is located, by the city or town, or if it's not in one of those, perhaps in the county area. And those jurisdictions are obviously run by elected officials, and by whenever a local government wants to regulate land use, they are required by state code to have a planning commission who advises them on those land use regulations and how that's to occur. So you have those property owners then having to deal with those elected officials and those planning commissioners. So those are probably the main players in that land use arena. But increasingly, more and more now, we have another group of people that get involved in that, and those are the neighbors or other residents and citizens of the community who have some interest in what's going to happen on that property. whether it's going to affect their property, whether it's going to affect their community. And so we basically have kind of like a triangle there. We have the property owner, we have the officials of the community, and then we have the neighbors and citizens of the community who have some interest. In the middle of all of that are the planners. We kind of put ourselves in that position to help everybody to understand how this land use process works, what are good practices to do, how to make sure we don't run afoul of the rules and regulations and laws that are in place, and hopefully how to help everybody get along and accomplish what they're trying to do, and make for a good community in the end and for a good use of property that the owner has. So those are probably the main players involved in this whole land use process.
Thanks. So those citizen planners who, that is the members of the city council, the planning commission, who deal with property owner requests and neighbors' response, can find themselves in a couple of different contexts, doing different types of functions. I wonder, Jordan, would you be willing to take a minute and talk about legislative acts and administrative acts and how they're different?
You bet, yeah. So local governments make decisions that affect the use of land. And when we talk about making good decisions and making legal decisions, essential to that question of making good decisions is the type of decision that's being made by the local government. And that decision, the type of the decision that they're making will be governed by different rules. And so the two primary areas that we're talking about are legislative acts and administrative acts. And depending on the type of decision that's being made, there's different levels of discretion that the local government can consider and rely on as far as information sources. The question comes up, can they listen to opinions and preferences? The answer to all those questions depends on if you're making a legislative decision or if you're making an administrative decision. So Craig has up here the kind of general overview of the differences between the types. With legislative acts, we're talking about decisions based on the weighing of broad competing policy considerations. You're deciding what you want your community to look like and what you want the rules to be that apply to the decisions. And then with administrative acts, you're no longer looking at, okay, what rules do we want to apply to the situation and the process. You're now just looking at, okay, we have an application to apply those rules to a given situation. So, legislative acts, those legislative decisions, those policy-making decisions, you can see the list there: general plans, annexations, decisions related to your zoning ordinance and your zoning map. And then depending on the nature of the agreement and the nature of the project, development agreements and plan unit developments may and often do fall into that category. And then on the administrative side, we're talking about specific applications to use your land in different ways: subdivisions, conditional uses, site plans, building permits. And then also when a decision is made that a property owner may not agree was legal and it goes to an appeal, those are viewed as administrative decisions as well as variances. And so you see the standards there that a court will apply to a decision that's made either in the legislative or administrative context. And we'll get into those in more detail with some of the stories and cases that Craig will tell and we'll talk about. So,
thank you. By the way, some of these slides have a lot of text on them, and I just wanted to make sure no one gets writer's cramp. A complete copy of the text slides is available at the utahlanduse.org website. So that's utahlanduse.org seminars. And there the latest version of this PowerPoint is printed out, at least the text slides. We don't take the time to include every photo that we use in the slides, but at least that'll provide you some relief from having to write all this stuff down. Thank you, Jordan. So when it comes to legislative decisions, that is, again, annexation, changing the general plan, writing the ordinance or creating the zoning map, that we are, the courts are basically going to give local government very broad discretion. The basic standard for land use decisions is whether it's arbitrary, capricious, or illegal, but that standard's a little different. Actually, it's a lot different for land use issues, whether they are writing the ordinance or basically administering the ordinance. So in terms of a legislative discretion, what discretion the city council has, the town board, the county commission, if an ordinance could promote the general welfare, or even if it's reasonably debatable that it's in the interest of the general welfare, we will uphold it. Now, as thresholds go, they're different in the law. We look at different tests that the courts look at. And sometimes it's really tough to get a court to overturn a local decision. And sometimes it's not that difficult if the action was clearly arbitrary. But the definition of arbitrary for legislative decisions is so broad, actually so narrow, that it's very difficult to challenge the decision of a local government in court when you're in the legislative arena. Because even if it's just debatable that it might advance the general welfare, then the courts are going to uphold that. Let me tell you a story. This is Draper. Actually, where it says Draper, that's Sandy. The line going across the center of the photo above the center is 114th South. So that's the boundary between the two cities, and the area north of that road is in Sandy, and the area south is Draper. And in the center is this 10-acre piece of property that is really quite a prime retail location. In fact, in the general plan for Draper, they show it as being planned separately. And the idea is this is going to go commercial. And of course, it's a great idea for it to go commercial because there are residential areas around it. Then there could be some great commercial support for the households that live there. So this is our property. Picture was taken just after the houses were torn down that were along 7th East, and now it's ready for commercial development. And Harmon's bought this property because it was just, obviously a great location for a Harmon store. And the general plan said that this area ought to be commercial, but it wasn't zoned that way yet. It was residential. And the idea seemed simple at the time. Just go ahead and make the proposal to convert it to a residential, or excuse me, to a commercial use, and life would be pretty good. This is the front of a Harmon's grocery store. Looks pretty good, doesn't it? This one's just a little farther north in Sandy on 7th East, and that's going to be the very attractive front. This is the front of the houses that face west. The backyards are next to the Harmon's property. Now, I've showed you how nice the front of a Harmon's grocery store looks like. And do you think you can imagine what the back of a Harmon's grocery store looks like? And we know which side is going to face these neighbors. So these neighbors are not amused. And I don't know any of them personally. And I'm just going to kind of, embellish the story or try to make it a little more engaging for everybody. But the bottom line is they're not happy. So they go to the planning commission and they protest. The planning staff has recommended approval of this project. And Harmon's has provided site plans and architectural studies and stormwater plans and traffic studies. And, they've done all the things that show that this is just going to be a great project for Draper. And the planning commission reviews it, makes their decision. The citizens are not happy. It goes to the city council, and it has to, because it's legislative in nature. That is, it has to involve a zone change. So only the city council can do that. The planning commission recommends, the city council makes a decision. So this goes to the city council. And there's a lot of public discussion. There's a lot of emotion. People are upset. And the city council, on a split vote, turns it down. And of course, at this point, Harmon's can't imagine what's gone wrong here. The master plan says that's what ought to go on there. They've shown, in fact, they've explained to Draper that the great sucking sound you'll hear as soon as they open their doors is sales tax dollars just flowing from Sandy into Draper. It's going to be a great cash cow for the city. And how could you possibly turn this down? Well, Harmon's takes it to court, the trial court rules, and then it goes to the Court of Appeals. So I want to turn to our handy dandy handbook, the ground rules book, and read what the court said in response to this case. So if you have a copy, turn to page 30, and I'm going to read the indented paragraph at the bottom of page 30. Harmon's presented ample information to the city council that would have justified Harmon's requested change in zoning classification. However, in attacking the city's action, Harmon's burden was not to show that the city council had no reason to deny Harmon's application. Rather, the burden was on Harmon's to show that the city's decision to preserve the status quo could not promote the general welfare. Although Harmon's presented evidence to support the position that the proposed zone was reasonable, the city council, upon the record before it, could have reasonably concluded that the existing use of the property for residential purposes consistent with the current zoning status was entirely appropriate. In other words, what the court is saying is, we don't want to be the planning commission. We don't even want to be the city council. When it comes to deciding what uses are compatible with other uses and what colors ought to be on the zoning map, that's up to the city, not the court. This is the clincher here, the next paragraph I read. It is a legislative body's prerogative to determine public policy, a judicial body's job to interpret the policy, and an administrative body's job to enforce the policy. Establishing zoning classification reflects a legislative policy decision with which courts will not interfere except in the most extreme cases. Indeed, here's the punchline, we have found no Utah case nor case from any other jurisdiction in which a zoning classification was reversed on grounds that it was arbitrary and capricious. Really? It never happens. So assigning the zone is local discretion. And this goes back to the legendary case, that the earliest nationwide case on zoning, which was this Village of Euclid versus Ambler Realty. This is Cleveland area in 1926. And it was authored by the only Utahn to ever serve on the United States Supreme Court, George Sutherland. And what he basically said is, he called it a rational basis. If there's any kind of rational basis for drawing these guidelines, then there is no taking. It's just a matter of trying to organize compatible uses together to make every use more enjoyable and more comfortable in its own setting. So basically, the city council's decisions rule. Interestingly enough, though, this is a picture of the sign that was put up when Harmon started building their store. Now, I just explained to you that Harmon's lost this case because the city had discretion. So the question then is, well, how did it happen that Harmon's is building a grocery store there? And the answer is that a couple of years went by, and it may be if there wasn't a change in the city council, there sure easily could have been a change of attitude in the city council. The city council, once again, on a split vote, made the decision about the zone of this property. And this time they agreed to zone it commercial. So does this mean if the citizens sued now, the citizens would win just like that position won last time? No, the citizens didn't win, the city won. So it's entirely up to the city. This is the Harmon store that was built there. And if you know your geography, you'll see the mountains are on the east here. This building is facing north, not east. And those property owners whose pictures we first showed, their homes are now to the west of a single story row of shops. And that single story row of shops is nicely done. And the back of those buildings is a decorative brick wall. And the area between the fence lines where the neighbors are in the back of that wall is landscaped very nicely. In fact, if it were in Elko, I think it'd be a national park. But it shows that Harmon's basically, I hate to say this because I'm an attorney, but rather than spend money on lawyers, they could have spent money on political campaigns. They could have spent money on improvements. They could have readjusted things. They could have made the whole thing more sympathetic with what the city and the neighbors wanted. And reaching consensus then, they got themselves a project and they were successful. Wilf or Jordan, do you want to chime in on your thoughts on this?
Yeah, if I can jump in real quick. What this points out is that these decisions, which we call the legislative decisions, they're broad policy decisions. They're opinion decisions. They're along the idea of, is this a good idea for our community and how do we want to make it happen in our community? So the list of things that you saw there earlier on and that Jordan went down, the adoption of the general plan, the adoption of your zoning ordinance, the zoning of property, all of those decisions are legislative. And they're fair game for opinion, for deciding how you want to go. It's really a political question. It really becomes a question of the politics of whether that's something that the citizens of the community want, that the elected officials want, and how they want to do it. And the courts are not going to insert themselves into that role of deciding what's good and what isn't good for the community, as long as it stays within those general guidelines that Craig had given at the beginning. Just one kind of side question. Craig noted that this property was shown in Draper City's general plan as being for commercial in the future. And yet the city council turned it down. Aren't they supposed to follow their general plan? Well, just to show you how discretionary by nature these types of decisions are, in the state of Utah, in state code, it even says that general plans are advisory only. They're not mandatory to be followed. Or you can decide how and when you want to follow them. So in this case, the city may have decided, well, yeah, it may be a good idea for commercial, but maybe not right now. And they have full discretion to decide how and when to implement those policies and goals that they've outlined in their plans, and then what kinds of rules and zoning they ought to put in place for that.
And maybe I'll just chime in to kind of reinforce the concept that Wilf is talking about, to say that later on we'll talk about administrative decisions and how you have to quote unquote show your work in a record. Here, I think it's interesting where to kind of illustrate how much deference the court gives to local governments and their decision making in the legislative arena. The burden is on the person challenging the decision to come up or say that there's no possible reasonably debatable purpose for the decision. So in other words, the city can make their decision, and they don't necessarily even need to explain why they made their decision for it to be a legal decision, just emphasizing the deference that courts give to those decisions, as long as they can be shown to in some way be in the public interest.
Great, thank you. Very helpful. Okay, well, just to illustrate this point now, the point is that the local government has great discretion. So let's look at another case. This is Sandy Hills Shopping Center, 9200 South 7th East in Sandy. Picture's a little old, but this is the same, this is 7th East, the same street, but a little bit north. And Smith Investment owns this property. It's been developed in the 60s with a shopping complex. It's kind of beyond its prime. It's now a fitness center, which isn't the A tenant in these kind of shopping centers, but it'll cycle and then it'll be redone. And it'll, of course, be a great opportunity for Smith Investment, or so they believe. Behind it is this large area of undeveloped property. If you look at it from the air, you can see just how significant this is. I think it was like 28 acres or something like that. and it's all zoned for commercial. So Smith Investment has bought the property and owned it, and looks forward to developing the land in a way that's going to be very beneficial for them. And then the city of Sandy comes in and says, you know, looking at it, we don't think that's really a good use of this property as commercial. We think it'd be better if it replicated the residential pattern around it there. So they zoned it R2 and said you can only build houses there. You can't build commercial. Well, at this point, Smith Investment got quite upset and said, you've taken our property. This is an unconstitutional prescription of our land, allocation of our property value to the public. And the appraiser who spoke at the trial, testified there, said this land was worth $1.25 million before it was downzoned. And the land is only worth $750,000 now. So these people have lost $500,000. Now, this is about 25 years ago, and that was real money. You know, you could buy a house for $500,000 back then. But it made a really great case teed up for the Court of Appeals. So on one side, you've got the property owner saying, you can't destroy my property value with your zoning. On the other hand, you've got the city saying, it would advance our general welfare if this area, which you can see would be awkwardly accessed for commercial use. We don't want commercial traffic flowing through those residential streets. And the city may have very well said, we just think there's a great need for residential development. And these are small homes on small lots. What a great mix into our housing needs. And I'm conjecturing what all this was. What I know from the reading of the case is that the city basically said, we think there's some legitimate public interest in doing this. Well, in your own mind, who do you think wins this case? The people who lost $500,000 or the city who thinks there's some marginal benefit to more housing? Let me tell you what the Court of Appeals said. Some people win, some people lose. It's the price we pay to live in an ordered society. In other words, you don't have any entitlement to the zoning of your property until you've got a project to build on it. And even then, not until you filed your application. That if the city wants to change the zoning, it is up to the city. The property owner has no vested right in the existing zoning of the property when that use has not yet been formalized in an application. So this land was downzoned. And I don't know really what's happened after that, but the Court of Appeals basically said, this is not a taking because some value remains. They can still build houses there, and $750,000 isn't chump change. So unless the government takes all the use of the property, eliminates all value, it's within local discretion to pick the zone. And the bottom line here is zoning helps everybody. It enhances everybody's property values generally. Houses are worth more because they're surrounded by housing, and businesses are surrounded by businesses. And this kind of artificial scarcity of land for businesses boosts the value of businesses and the value of business property. So this is basically just the way we function in our society. And that going back to Euclid is the best use of the zoning power to sort these things out on a political basis, not a legal one. Any thoughts, Jordan or Wilf?
I think, and just to emphasize again how the political nature of these kinds of decisions. First of all, the courts said there was no taking because all of the value wasn't gone of the property in it. So in essence, what they're saying is, in order to really justify taking, there has to be no remaining value of the property. There was value here, as Craig pointed out. They could still develop it for housing. So there was still some benefit to be had, both for the community and for the owner. But these kinds of decisions, when the council makes them, again, as we pointed out, communities are required to have a general plan. They're also required to have a planning commission. And the elected officials cannot make these kinds of decisions until they first have received a recommendation from the planning commission. So in order for this zoning to have happened, the council must first have gotten a recommendation from the planning commission as to what that zoning ought to be. The council doesn't necessarily have to follow it, but they have to get that recommendation. And just to emphasize the nature of public opinion in these decisions, the planning commission by state code is required to hold a public hearing before they make their recommendation on what to do on these kinds of legislative decisions to the council.
And I think it's important here to also note the principle that just because when our office gives training to local governments a lot, we often point out that local decision makers have a solemn responsibility because they're put in the position to make significant decisions that impact private property rights. And so I think it goes without saying, and it's important to note that that decision significantly impacted that property owner, and decision makers, government officials should really take that into account when they're trying to weigh the public interest with private property rights in making good decisions to exercise that discretion wisely. So
Thank you.
And it's just good to remember as well too that for these kinds of legislative decisions, there's only one body that can make a legislative decision, make these kinds of legislative decisions, and that's the elected officials. The city council, the town council, the county commission, the county council. They're the only ones that can make these kinds of decisions. Everybody else just provides feedback and input and advice to them, but the elected officials are the ones who decide it.
Thank you. Okay, so these are zone changes, and that's just one of the types of legislative decision. Let's talk a minute about the ordinance itself. This is an example of a design control, design standard ordinance. This is Summit County, and this Home Depot outside of Park City on the east side of US 40 is a better looking store, in my opinion, than the one I go to in Ogden. And the reason is that Summit County has decided to devote their budget and their energy, their staff time to monitoring the design of structures. And so this is within the local discretion of the legislative body. You can write the ordinances so that they control the way things look. It's expensive, but it's not, this isn't a legal question. It's a political issue of whether or not local government wants to devote its energy to do this. And there's a lot of moving parts in making a legislative decision. Obviously, some companies that might want to come to your community just can't afford to meet the design standards. And so they go other places. Some companies decide it's worth the bother or the hassle, the time, and they come and participate and develop a more attractive store than they would otherwise, at least in the opinion of the people who run the design standards. But it's a legislative act. And if it's reasonably debatable, that advances the general welfare and it doesn't conflict with state statute or federal statute or the court opinions, then these kinds of legislative decisions are going to be fully legal and enforceable. Old Glory waves over Monterey, California, Charleston, South Carolina, these places where they do in fact tell you what color to paint your door, because the community has decided it's in its interest to develop those kinds of standards. So in the little town I live in Plain City, we don't have a historic district or any kind of regulations. In Salt Lake City, they have a full-blown landmarks commission. In Park City, they regulate to a great extent the way buildings look. But it's a matter of local choice. It's political. It's not a legal issue generally, so long as some economic use is preserved to the property owner and everything's enforced in an even-handed and uniform manner. So this, for example, a development parcel, according to the sign, 57 acres. Well, you think, well, let's buy that land and develop a lot of property. At the time the picture is taking, the zoning is 1 unit per 40 acres. So this is basically one building lot until somebody develops a very charming and engaging proposal and the local legislative body decides to relax the zoning and change it. And this picture's old. It's probably 15 or 20 years old. I don't know. But by this time now, I believe this is part of the land included in the little community of Hideout. And there are hundreds of townhomes and other projects built, not hundreds of projects, but certainly hundreds of dwellings in areas like this that before were not ready yet for development. So it's important, the general plan does not control every single zoning change, but over time, these political decisions, the zone changes, the general plan and such, the ordinance and the text, help a community evolve to be what it would like to be. Although at any point, the local legislative body can say this project isn't ready yet, just like they did for Harmon's. It's not that we're not going to follow the plan. We don't have to follow it in each instance right now because it's an advisory. And as each building block is added to what our community needs to be, then we can take a look at those decisions one by one and decide what's best right now in the context of what we are planning to be over time. Any other thoughts, gentlemen? Okay, moving along. So remember, the Planning Commission recommends, the elected legislative body decides. And this is all legislative discretion. If an ordinance could promote the general welfare, or even if it's reasonably debatable that it's in the interest of the general welfare, we will uphold it. So that's the general rule. So you think local government basically can just do anything they want. That's not exactly the case, because while the courts are not going to interfere with local discretion in this area, there are other problems that can arise. And it's a political decision. So guess what? It could be very political. It could involve the ballot box. This is Krejci v. Saratoga Springs, case decided, it's 3 or 4 years ago, maybe 5. 75-acre parcel, the triangular area in the center of this in Saratoga. Of course, you can see Utah Lake off to the left. And this golf course community, single family lots, is pretty upscale. In fact, it may be one of the most upscale areas of Saratoga Springs, if not the most. It's been there a while, and people have an expectation that they're going to have their lovely community with open spaces and single family homes. So the city and the guy that owns the property, the individuals, the company that owns the property, decide to change the zoning to allow for some townhomes. Now, I'm sure these are going to be very nice upscale townhomes, but they are still townhomes, and the residents in the area are not pleased with that. So this is not an easy process, but within the time frame allowed under the ordinance and the state statute, which is a matter of days, a notice is provided to the city clerk. They're going to put this to referendum. They're going to gather signatures. Then within a certain amount of time, weeks, they have to gather a certain amount of signatures. And in Saratoga Springs, they did this. And then the Utah Supreme Court was asked to weigh in on whether or not this single lot rezone was a legislative act subject to referendum. And the court said it was. So this went to vote. The voters turned it down, and it did not develop into townhomes at that time. So this is the other side to legislative discretion. The local city council has a lot of discretion, but they also are, any legislative act by the city is subject to referendum by the voters, who can pull the decision in a limited amount of time to the ballot box and then re-decide what the city decided. The citizens also have an opportunity to initiate their own zoning ordinance if they wish to do that, although that's rare. What are your thoughts on this, Wilf or Jordan?
Well, I would add to that. So this is an instance where most people think whenever you're dealing with a land use issue and you don't like the decision of the land use decision that's made, you go to the courts. And as we'll see on the administrative side, that's a little bit more appropriate and has a different outcome there. But in this case, as Craig has just shown you with the decisions of Harmon's and Smith's to go to court and try to get the decisions overturned, on these legislative decisions, courts are going to stay out of those decisions. Those are legislative, those are political, those are policy decisions. Those are not the kinds of things that the courts are going to get involved with. However, our Utah State Constitution does guarantee that the citizens have co-equal power with the legislative body. So if the citizens don't like a decision that was made to rezone property, or to what they adopted in their zoning code, what provisions, or a provision that they adopted in their general plan, then those citizens have the right under the state constitution to go collect signatures from their neighbors and the residents in their community and get the matter put on the ballot and put it to a vote. And that's kind of the appeal, I guess you would say, that comes about for these legislative type of decisions in land use.
The court of public opinion, as they say, right?
Right.
So this is an evolving thing in Utah. This is a big deal. Next case we'll tell you about, for example, this is the old Cottonwood Mall site in Holiday. And those of us in the valley, of course, know that this land's been sitting vacant, grossly underutilized. It's just a prime, terrific piece of property, and was Utah's first indoor shopping center. But over time, that use cycled out, and Ivory Development, Woodbury Corporation, came up with this proposal. Hundreds of millions of dollars would have been spent to build single-family homes, which you see at the far side of this proposed, this rendering. Townhomes and apartments along the corridor, office, retail. I mean, this would have been the hub, the vibrant commercial hub of Holiday. The land's already zoned for mixed use. So everybody's in pretty good shape here. The developers think, great, we got a mixed use zone. We'll go in and put in this project, and the city we'd just have to get the city on board and we're fine. So Holiday City, in what they styled as administrative decisions, amended a previously executed development agreement, and they also approved a site plan. And this is what the site plan looked like. That's what the developer provided to the city. Residents nearby were not happy with the idea, and so they tried to put it to a referendum. And the developers protested, the town did too. So the developer and the town, the city, go to the Supreme Court and say, look, this is just an administrative decision. We're approving a site plan. And by the way, this is the reason when we did our little chart that showed administrative and legislative and what's what, we put development agreements ? And planned unit developments ? What that means is if the project's big enough and complicated enough, then a court might rule that it's actually legislative, not administrative. So what the Supreme Court said is basically that looks like a zoning map to us. And so because of the size of the project and the number of public policy issues involved, broad sweeping policy considerations in its adoption, they said the voters should have a crack at it and should be able to comment. Thoughts from Jordan or Wilf?
The reason that the city and the developer said and thought that this was an administrative decision is they said the city has a zone in place, has already zoned this property mixed use. And in the ordinance, in their ordinance, it said, all right, this is mixed use, but it didn't detail how much could be residential, how much could be commercial, anything like that. It just said, it can be mixed use, and bring us a site plan and we'll decide. We'll take a look at it and decide what to do. When the court looked at that and considered it, they said, you don't really have any policy decisions made in your ordinance. You're kind of leaving that up to the site plan process, which the court said to us really seems like that's a policy making process. That's legislative, therefore it can be subject to a referendum. Where's that line? Where do you get to the line between what's considered administrative and legislative? And it's not real clear at this point. That's why on that chart that Craig had on these kinds of things, he had a question mark there. I kind of liken it to years ago, the US Supreme Court when they were considering a case on pornography. And the question was, when does something cross the line and become pornographic? And the court said, basically, well, we'll know it when we see it. That's kind of where we're at here. We don't really have a bright line as to when you cross the line and become administrative versus legislative. It's kind of like, we'll kind of have to see how far you go in that policy-making process to decide whether it's legislative or not. So we don't have a real clear, bright line on that from our court decisions at this point.
And I think it's worth noting that for practical considerations, it's not difficult to determine what is administrative and what is legislative on your day-to-day. But what this court did point out is that, hey, there are certain types of planning tools, land use tools, zoning tools that have developed over time to create more flexibility and maybe in certain cases more predictability for one party or another. And those newer tools, they're the ones that tend, planned unit developments, development agreements, and those types of things. Those are the areas where you kind of have to pay a little more attention and make sure that you're following the rules as far as what is administrative and what is legislative, and think about those things. Are we making are we making our decisions based upon broad competing policy considerations? Who's making the decision, and those types of things? And in those areas, you have to pay a little more attention and make sure you're doing it right. So,
thank you. So, by the way, the court ruled that the amendment to the development agreement was administrative in this case, but the site plan was really a legislative act. So it's in the biggest projects, it comes up, and Jordan's point is well taken, that it's certainly not something that makes our general land use practice unpredictable, because by and large, you've really got to have a significant project in a smaller community to have the boundaries of these definitions stretch too far. So the bottom line, to summarize, then, these are legislative acts and they're subject to broad discretion. They're also subject to referendum and initiative. And by the way, if you're interested in the referendum business at all, Chapter 16 in the Ground Rules book includes a discussion of the process. Although there's no way to go through the detail, you really have to have a skilled land use attorney at your elbow when you're going through to propose an initiative or a referendum, because one misstep and of course everything falls apart. But the number of signatures needed for different sized communities is there in the book, for example, just to give people a better overview of how this happens. Okay, let's shift gears. Let's talk about administrative acts. An administrative land use decision will be upheld if it's supported by substantial evidence in the record and not otherwise illegal. So we're leaving the legislative discretion. We're no longer making political decisions. Now we're in the administrative arena, and that's an entirely different animal. Administrative decisions are applying the ordinance. So the policy issues have been settled by the drafting of the ordinance. We're not doing policy anymore. We're just basically trying to decide if the application as submitted complies with the ordinance. Who'd like to tell us a little bit about vested rights? Jordan, is that a good one for you to start us out on?
You'll need to unmute him again, Craig. He muted himself and can't unmute himself.
Well, we need to fix that somehow. Go ahead. Let's see here.
thank you. Sorry about that. I decided I needed to cough and I thought I'd be polite and mute myself, but then I couldn't unmute myself, so I apologize.
Well, I'm master of the universe here, so you need permission to do anything. These are administrative acts that I'm This isn't legislative discretion.
Yeah, and you asked me to talk
Yeah,
about vested rights.
Talk about vested rights, if you would.
Yeah, so now we're pivoting a little bit here, right, to administrative decisions. And when we talk about vested rights, the question was asked in the chat previously of whether or not the zoning was changed before or after they purchased the property. And on the, up until you propose a project, the city can change the zoning and the city can make new decisions, and they can reconsider their prior policy considerations. There's a point at which their discretion to do that ends with a given project, and that's when we talk about vested rights. So a party obtains a vested right essentially in Utah when they submit an application and they pay a fee for some sort of an administrative approval, like a site plan or like a subdivision approval or something like that. And at that point in time, it locks the rules in place. The city can continue to change the rules for projects that haven't been proposed. They can continue to change their zoning and change their policies. But once someone comes in and says, okay, I'm ready to develop my land, Utah courts and the Utah legislature have said that locks in the rules, and the city doesn't have the authority anymore to change the rules midstream, as the court says. So it's a principle of predictability and fairness to say that, okay, once you submit your application and pay your fee, then the rules are locked in place, and those are the rules that govern the project. And Utah, that's a little different than some states. In some states, you really don't obtain a vested right until your project proceeds and you start to substantially rely on some sort of an approval or some sort of an ordinance. And it creates a situation where in some states, a developer puts significant expense and money into a project before they have the certainty of knowing that the rules aren't going to be changed in midstream. Utah has said, hey, we don't want the waste and the difficulty and the unpredictability that accompanies those situations. So Utah's designated itself as what we call an early vesting state, in that when you submit that application and you pay your fee and you begin the review process, then it locks the rules in place.
Super. Wilf, tell us about the exceptions.
There are two exceptions that apply to this vesting of the rights to go ahead and develop. The first one is a fairly rare instance, but it does happen. It has happened in the past. And that is if there is that the community finds that there's some what's called a compelling countervailing public interest, that something really serious would happen if you allow somebody who has essentially a vested right to go forward with it. A good example of that has happened in a couple of our communities around the state. Let's say you get a subdivision that's approved on a hillside area. People start building houses on those lots. And not long after some of those houses get built, some of those houses start sliding down the hill. As Craig likes to say, and I love to steal his joke on this, he says, they're not mobile homes. Everything moves down the hill except for the mortgage, which stays in place. But what that essentially means is that somebody didn't see something. They didn't get maybe all the information that they needed, and there's a real serious problem here. Well, people already have these approved subdivision lots. So somebody now comes in and says, well, I have a lot, a legal lot, it's all approved, I want to build. And the city says, we've got a really serious problem going on in some other houses in these areas. And we therefore find there's a really compelling countervailing public interest to not let you exercise your vested right, because there's a danger to the public, a danger to you and to the public, in order to allow you to go ahead and exercise that right. So that's kind of the serious nature of which it would require for a community, in order to stop, not honor what's essentially a vested right. In that case, they may then require that the property owner is going to have to do some more work, maybe get some geologic studies and some other things to prove that they can go ahead and build on that property, but it's more than what was there initially. That's that vested right and the countervailing interest. The other exception to the vested right rule is what's called the pending ordinance rule. Oftentimes we call this a moratorium, and that is the community decides that maybe they want to look at changing their zoning ordinance, their zoning code, and what it says and what it allows and how it allows for those things. But in order to kind of stop the rush to the counter, in other words, by saying, well, we want to think about changing the rule, all of a sudden you get people rushing into the city to apply for doing the thing that they want to try and change. The city can essentially stop that rush to the counter by taking a formal action, by saying we want to, by putting this on the agenda for a meeting with the Planning Commission or the City Council, and saying we are hereby beginning a process to look at whether we want to change this provision in our ordinance, whether to allow gas stations in the commercial zone, say, or something else, whatever it may be. But they've actually taken that formal step to say, we're going to look at whether we ought to change this, the pending ordinance rule. And now the city has essentially bought itself 6 months. Our laws allow for the city now to take 6 months to take a look at and consider and whether they ought to change those rules and how they ought to do that. And in that 6 month period, generally a person who wants to do the thing that would be affected by that change is not allowed to do it, or they're at least advised that if they go ahead and do it, that they may be affected by whatever change is coming and they'll have to change what it is that they're trying to do. So that's the other exception to someone having a vested right, is that the city has formally declared that they want to look at changing the rule.
Thank you. Okay, so basically what this means is the land use authority must thus determine whether legally and factually the application complies. If it complies with the rules in place when the application was filed, including pending ordinances, then approve the application. If it does not comply, then deny it. In either case, we explain why on the record. It's important to remember that the land use decision of a land use authority is an administrative act, even if the land use authority is the legislative body. Wilf, tell us about land use authorities. What does that mean?
You bet. And this works well because we did get a question on the chat asking about what was called a PUD application. And is there a PUD board, and is that the Planning Commission? What it really goes to is an administrative act. When we talked about legislative acts, we said the only body that can make a legislative decision is the elected body, the council or the commission. They're the only ones that can make a legislative decision. For administrative acts, the state code designates that those actions or those decisions are made by what's called a land use authority. That you see there in that term on the slide, a land use authority. The land use authority is a body or a group or even an individual that's designated by the council, by the elected officials, to make the administrative decisions. And it can be essentially any body or any person that the council so decides. So oftentimes the Planning Commission is designated as the land use authority for any number of types of decisions, conditional use permits, site plan reviews, even the approval of planned unit developments, PUDs, as the questioner asked in the chat just recently. It can also be staff. The council can designate staff to be the land use authority to make certain kinds of decisions. Most commonly, that decision is given to staff for issuing building permits, doing the zoning review that's necessary to make sure a building permit application complies with the zoning rules. But other bodies can be designated as well. The council can even designate itself to be the land use authority for certain things. We generally don't recommend that because elected officials are really good at making legislative decisions. They want to listen to the citizens, take their opinions into account, and kind of use that as a basis for their decisions. That's not a good basis for making an administrative decision. And so we generally don't recommend that the elected officials designate themselves as a land use authority, but it is possible. But bottom line is, land use authority is the body or the person that makes a administrative decision, and they're designated by the council to do so.
So just a clarification, and excellent, thank you, Wilf. The critical thing to remember is there may be more than one land use authority in a given community. So the planning commission may be the land use authority on conditional use permit. The city council might appoint itself the land use authority for subdivisions, or vice versa. It really depends on the preferences of local authorities. But legislative officials, elected officials, when they're acting in an administrative capacity, follow the same rules as everyone else, whether they're elected or not. So just to clarify. Jordan, would you tell us about conditional use permits and a little bit about the law related to them?
Yeah, so when you look at a zoning ordinance, typically, you see different types of uses and how they're addressed. And the three main categories that you see are permitted uses, or by right uses, we call them. And then you see conditionally permitted uses, or just conditional uses. And then sometimes you'll see prohibited uses. Other times you just see a provision saying if it's not permitted, it's otherwise permitted, it's prohibited. Permitted uses, as long as they comply with all the requirements in the code, they're approved. Conditional use permits, the idea behind these is that they are for all intents and purposes, they're largely a permitted use in the zone, but there's also a recognition that there are certain types of uses that may carry with them certain characteristics that may have traits or aspects to them that can impose compatibility issues on surrounding uses. And so a local zoning ordinance can identify what those are in any given case. And then they can say, and then what state law says is that with those uses, in addition to the requirements in the code, you have standards in your ordinance to say, okay, these are areas where there may be potential detrimental effects, or these are issues that might need to be addressed with conditional uses like traffic, noise, lighting, things that tend toward nuisances and those types of things. And with conditional uses, according to those standards that are in the code, a land use authority has additional discretion to say, okay, under these standards, we're going to impose conditions to mitigate any reasonably anticipated detrimental effects that we identify related to that use.
Great, thank you. So these are the questions then. 1, what are the reasonably anticipated detrimental effects? 2, can they be reasonably mitigated? And 3, if so, what reasonable conditions does the ordinance allow to be imposed? And this is the process. Again, this is administrative, and we are going through the process not of making the policy about which uses are allowed, which uses are desirable, but with some uses which might need to be moderated in a given location, we're trying to decide how to take the things we know about those kinds of uses, like gas stations and churches, and make their impact on the neighbors a little less than it otherwise would be. So let's tell you a story. This is Dannon Yogurt in West Jordan. You can see the blue skies are shining brightly on this lovely campus. They've got acres of grass, and they are greatly favored by West Jordan. West Jordan did a lot of work to get Dannon to be the anchor of a new industrial park on the west side, and it certainly set the standard for what this is going to look like. Let me show you how much Dannon and West Jordan get along. This is the street sign right by this development. So where Dannon is, there is prosperity. I'm thinking that West Jordan and Dannon get along just fine. There is a problem, however. Right next to the Dannon plant is a construction yard. And you can see this is not exactly the same level of attractiveness that Dannon has established. And Dannon, all I know about this is what I read in the case, but it rings loud and clear that Dannon was not amused by this kind of use next to its beautiful campus. So if you're looking from the east side, looking to the west, to the Ochre Mountains, you see this construction yard before you see Dannon. Well, that may have been there before the Dannon plan was built, but there's all this undeveloped land around Dannon. And so Wadsworth Construction comes in and they're proposing another construction yard. So Wadsworth comes to the city council, comes to the planning commission and tries to get approval. Now, normally when we consider what we refer to affectionately as public clamor, we think of residential neighbors. But in this case, you've got industrial neighbors, and Dannon themselves, their leaders, come to the planning commission and say, don't approve this use. We don't want that next to our plant. We don't want it in the construction yard, or we don't want it in the industrial park. And I don't know what they really said, though. What they may have said is, look, we were assured this was going to be a beautiful series of industrial campuses, that we weren't going to have that kind of use. So just say no. Don't allow Wadsworth to build a construction yard. So again, this is the administrative rule. An administrative land use decision will be upheld if it's supported by substantial evidence in the record. Wilf, what is substantial evidence?
The rule for making an administrative decision is you have to have evidence on the record that they are either meeting the requirements of the ordinance or they are not. And the standard is substantial evidence. Substantial in this case doesn't mean a lot of evidence, like you sometimes think, when you say, wow, that's substantial. What it really means in this case is that there's some substance to it, that there's something to it. We use this great evidence-o-meter, and I'll try to demonstrate it here. Way over on this end, if you're like watching Perry Mason and they're trying to determine, a jury's trying to determine whether somebody committed murder, and the standard in those kinds of cases is clear and convincing evidence, beyond a reasonable shadow of a doubt. That's clear over here. You go up a little bit on that and you have preponderance of the evidence. That is, a lot of the evidence or most of the evidence supports a certain outcome or a conclusion. You get way over to the other end and it's what's called a scintilla, which means just a little bit. There's maybe just a little bit of evidence saying something that you're looking for. Right up over in this range is what's called substantial evidence. In other words, it's got some substance to it. There's something there for you to hang your hat on. In other words, you have the responsibility to decide whether the application meets the requirements of the ordinance. And in deciding that, you're given information and studies and material and people saying things. And is there some evidence? Is there something to the information that you're being provided that allows you to say, yes, we can see that there is some evidence here that they're complying with the requirements of our ordinance, or in the case of turning it down, we don't see that there's any substance of information that allows us to make that decision. And so that's what's meant by substantial evidence, something to hang your hat on.
And I'll add, maybe, Craig, I often like to think of it in terms of piles of evidence. And, in some cases, when you're making a decision, like when we're talking about preponderance or more, the pile of evidence supporting your decision has to be bigger than the pile of evidence that doesn't support your decision. But with substantial evidence, you might have two piles and one might be a little bigger than the other. But if this smaller pile is still sufficient evidence and it's relevant evidence and it's factual and it's credible, then you can make your decision based upon that smaller pile of evidence, insofar as it is still good, like Wilf said, substantive, reliable evidence.
So let's define the word evidence for a second here. So evidence, what's the difference between what's evidence and what's not evidence? Does somebody want to weigh in on that?
For me, again, you have some good explanations there, right? It's relevant, it's independent, it's from an expert or otherwise credible. What is not evidence is what we refer to typically as opinion or preference or conjecture. It's not based in any factual determination, or it's given by someone who maybe doesn't have experience in the area. So if we're talking about traffic, a study from a traffic engineer with experience in traffic studies, that's going to be substantial evidence. That's going to be good evidence. But someone just standing up in a public meeting and speculating that this project will make the roads fail or it will cause traffic to be too much, that's probably falling out of the realm of evidence and into the realm of opinion or conjecture.
Great, thank you. Okay, so we want to go to the case. Now we're back, we're discussing whether or not Wadsworth can build this construction yard. Let me go back to the aerial photograph here. So again, you've got this undeveloped area, and the Planning Commission and the City Council both hear this matter. The City Council on appeal from a decision of the Planning Commission denying the use. Wadsworth pushes it to the City Council, and these are the findings that the City Council entered on the record. I'm reading from the Ground Rules Handbook, and I'm on page 34. These are the 4 findings that the city said supported their decision to deny. 1, the city's made a significant investment in bringing Dan into the area, and the attributes which attracted Dan into the area need to be maintained. Outdoor storage is detrimental to the area, making the area less attractive and injurious to the goals of the city. 2, outdoor storage may be considered to be a nuisance to neighboring property owners. 3, outdoor storage would encompass the majority of the parcel. The area and intensity of outdoor storage are much different than that of neighboring property owners. 4, outdoor storage is detrimental to the existing and future businesses in the area and is not harmonious with the goals of the city. Now, you, as our viewer, may have read a lot of minutes and read findings like that sound like, that's, the city's intent is clear here, that's deliberate, it's measured, and there's the response. The problem we have is those aren't facts. There's not a fact listed here. There are statements of public policy. And where do we find appropriate statements of public policy? In the legislative arena. The public policy issues have already been settled. How do we know? It says it's injurious to the goals of the city. How do we know what the goals of the city are? Well, read the ordinance. The goals of the city are in the ordinance. In fact, if you read the preface to the ordinance, it'll say, this ordinance is to create our goals. We want beautiful tree-lined streets. We want economic prosperity. We want increased property values. And in order to create all those things, we hereby create the zoning ordinance. Well, so when did the city have the chance to decide whether this use was desirable? When Wadsworth applied or when they wrote the code? Well, when they wrote the code. How can they say that having this in the zone is injurious to the goals of the city when it's the city who had all these thousands of choices of uses they could put in this zone, and they picked outdoor yards, outdoor construction yards as one of the uses that they found desirable? I'm reading on page 36. This is the Court of Appeals decision. In denying Wadsworth's application, the City Council relied on its finding that the city's made a significant investment in bringing Dan into the area, and outdoor storage is detrimental to the areas and injurious to the goals of the city. However, the only evidence in the record supporting this finding are the concerns expressed by neighboring landowners. The record does not reveal whether the commission staff actually investigated the concerns raised at the public hearing, or why they concluded that outdoor storage on Wadsworth's property, which is located in an industrial zone, would be adverse to the city's goals. And then going on, similarly, the sole evidence supporting the City Council's determination that Wadsworth's outdoor storage may be considered a nuisance is the concern raised by neighboring property owners regarding potential increases in rodent traffic and dust. Although the zoning ordinance authorized the City Council to deny Wadsworth's application if it was deemed a nuisance, the City Council did not find that Wadsworth storage would actually constitute a nuisance. So this is not too complicated. The city said in the ordinance, they had standards in the ordinance that we've talked about briefly, said, okay, you can impose conditions to I'm just guessing at what the ordinance said. What the court says is it said you could deny an application if it was deemed a nuisance. Do you remember the language the court adopted or the city council adopted? Outdoor storage might be considered to be a nuisance by neighboring property owners. It might. Is it or isn't it? What the court is saying is if you have to deem it a nuisance, then deem it a nuisance. It has to be a finding. So in the record, there has to be a finding of what evidence there is that actually constitutes the conclusion, supports the conclusion that it is or will certainly be a nuisance. Now, what the city could have done is relatively obvious. Wadsworth Construction is a big outfit. They may have other construction yards. If the city staff went out to do an inspection of the other construction yards and they found what they considered to be a nuisance and documented it with photographs and, odors or dust or mice or, whatever they did, if they had documents showing that those nuisances actually existed, then bingo, we've deemed it a nuisance. But the opinion expressed by the neighbors was not sufficient consideration to uphold this decision. So the Court of Appeals basically said, you need to grant this approval and you need to allow it to be built. This is the Wadsworth construction yard that was built. And this, I took these pictures while it was being built. So you can see there's landscaped area. You can see the curbing. There's going to be landscaping there. You can see an 8-foot tall concrete wall. The gate that's going to cross this area is no doubt going to be opaque, so you can't see through it. And when you're driving through this area in your pickup or your car, you're not going to see what you did see through the wrought iron fence on that other place that might detract from the neighborhood as much as the other place does. So these are the kind of conditions appropriately attached to a conditional use permit, which can be mitigated. And the critical word there is mitigation, not elimination. The critical thing is that the information supporting the decision has to be on the record. Findings of fact and conclusions of law. Other thoughts, Jordan or Wilf?
I would just add that, so what you see here now is, of course, you had the court case and the city lost the court case because they weren't doing administrative processes. They were doing essentially a legislative process in their decision process on this Wadsworth application. From what the pictures that you're showing, the city then apparently went back and they appropriately went through the administrative process and allowed the construction yard with conditions based on standards that they had in their ordinance. Can the city change their code? Of course they can. They could go back now and take construction yards out of their code as a conditional use if they decided that, after we went all through all of this with Wadsworth and with Dannon, maybe we've decided that we shouldn't have construction yards in our zones as a conditional use. Fine, they can do that. They have to go through the legislative process, but they can't do it when they've got an application pending that now has a vested right to go forward under the code as they had it written at the time.
And maybe one of the cautionary tales of this case is, local governments, it's appropriate to have goals and for those goals to be reflected in your general plan or stated in your general plan. But it's also really important that whatever requirements you have in your code reflect those goals. Understanding that those requirements need to be predictable and understandable. But if you are looking at your ordinances regularly and they're producing outcomes that don't align with what you deem to be your goals as a community, then you probably need to change your ordinances, update your ordinances to better reflect those.
Okay, thank you. Be a record. And a recent case that the Utah Supreme Court recently decided highlights this in a dramatic way. McElhaney family in Moab owned the land on the end of this cul-de-sac, Arches Drive. You could go off Hillside Drive to get to it. You can see it's, you have to go by a lot of houses to get there. A bed and breakfast is allowed use in this zone. but it's a conditional use. So they come to the planning commission and to the city council on appeal to find out if they can get a conditional use permit, and they're turned down. And I would assume, based on what I read in the case, that a lot of people who live along those streets are saying a good place for a bed and breakfast is not at the end of the cul-de-sac passing all these homes. So the Utah Supreme Court took this case. Now, the Supreme Court does not often hear individual land use cases like this, but I think they wanted to make a point. And the point is that the city of Moab, in turning this down, did not provide enough information in the record for the court to review. And this frustrated the court. This is what the court said. It was the council's responsibility to define the basis for its decision, not the district court. Simply stated, if a city council is going to sit as an adjudicated body, it needs to produce findings of fact capable of review on appeal. So this case set a new standard, basically, that the court is not going to allow, the appellate courts are not going to allow the trial courts to be the planning commission either. And so what they're saying is that the local body, if it doesn't put the basis for its decision on the record by citing facts and basically how they're applying the law, then they're going to have to go back and do it over, which is what happened here. They remanded it back to the city of Moab to do it again. This is the next case we'll talk about as we wrap up administrative issues. And this is an interesting case. As you can see, we've got Davis County suing the city of Clearfield. A little ironic in that we've got one government entity suing another. Basically, this takes place a number of years ago, 25 years ago or so. This is Clearfield State Street. And there's this home that was built in time when the architecture was probably really cutting edge. It was built by a prosperous family who didn't mind having their home on State Street because they could kind of, show off their good taste and that life was pretty good for them. Another house right next door also was built, a larger home for a larger family, I'm sure, in a different time. And now those buildings are not suitable for family life. State Street has grown to be a major regional connector, all of which is great. You've got these existing buildings with some useful life left. Davis County says, great, we're looking for facilities that the community needs. We'd like to put an alcohol recovery center in one of them. And the city had to respond. One of the things that makes this case, of course, even more interesting is that the North Davis Junior High School is located right across the street. Well, luckily on our panel today, we have someone with firsthand information about this case. Wilf, would you like to tell us a little bit about what happened?
Sure. This is the case that I always say made my reputation as a planner. It was early in my career. I was a planner working for Davis County. Davis County provided planning services to a number of the communities in our county because they were not big enough yet or had not decided that they wanted to hire full-time planning staff. And so the county had the wherewithal and was providing assistance to them through contracts. So the county had a contract with Clearfield City to do their planning services, and I was the planner assigned. Notice the name of this court case, the title of it, Davis County versus Clearfield, as Craig has pointed out. So I was walking an interesting tightrope here, essentially kind of working for both entities. As Craig mentioned, this was a conditional use permit for a group home or a group facility for an alcohol recovery center proposed by the Davis County Mental Health Department as one of several that they operated throughout the county. And as you can imagine, the residents, the neighbors of these homes, of these proposed facilities, were not happy. They were very upset about the proposal to put the group home like this in their neighborhood. And the meeting was very packed and very boisterous and very loud. At one point, the chair of the meeting even asked the question and said, "All those who are here in favor of this proposal, raise your hands." And it was total silence, crickets. And then ask all those who are opposed, and the room erupted as people leaped up and waved their arms and basically said, "We are opposed to this." And when the Planning Commission and then ultimately the City Council as the appeal authority, and we'll talk about appeal authorities a little bit later, but as they both made the decision to turn down the conditional use permit, one of the reasons that they cited was that the residents did not want it, the neighbors did not want it, and that was one of the reasons for turning it down. Another provision, another thing that happened in the meeting was that residents would come up and make their comments. And one of the common comments that was heard was the residents would say, everybody knows that around facilities like this in the neighborhoods around them, that the crime rate just goes through the roof. The crime rate is really bad. We know it is. You hear about this from other places and other people. It's bad. Well, in the meeting, because it was such a large and boisterous meeting, the police chief was there with a couple of his officers to kind of keep an eye on things. And the chair in the meeting saw the chief there, and after receiving a number of these comments, asked the chief to come forward and said, "Chief, can you tell us, will you tell us, is that the case? Is the crime rate higher around these kinds of facilities?" And the chief said, we have found that if they are well managed and well operated, that no, the crime rate is not generally higher in the neighborhoods around these kinds of facilities. Well, in the end, when the Planning Commission and then ultimately the City Council turned down the permit, one of the reasons that they cited for turning it down was that the crime rate is higher in the neighborhoods around these kinds of facilities. This case is famous because it brought the term public clamor into common usage in our land use issues, that administrative decisions are not appropriately made by public clamor or through public clamor. And that's essentially what was happening here. We talked about substantial evidence and having evidence. The residents, the neighbors saying that the crime rate was going to be higher is not credible evidence. They don't have anything to base that on, and they don't have any particular expertise to do that. The police chief, however, is likely considered to be a credible witness or a credible source of evidence because he has experience in these areas with these kinds of things. And so, in essence, the Planning Commission and the council made their decision based on the public clamor and not on the credible evidence from an expert, the police chief. And one of the reasons why the court ultimately decided that this decision could not stand.
Thanks. So again, I just want to read a little bit about what the court said here. I'm in the ground rules book and on page 84. It says, nowhere in the transcripts is there believable information or evidence on which the Clearfield City Council could have rationally believed that the proposed mental health facility would pose any special threat to Clearfield City's legitimate interest. With regard to concern over real estate values, no studies were made, no opinions were given by professional real estate appraisers, nor was there any credible evidence of reduced property values produced at the hearings. The opposition did not have factual support in the vague reservations expressed by either the single-family owners or the commission members. The reasons did not justify denial of the permit, even though they would have been legally sufficient had the record demonstrated a factual basis for them. The denial of a permit is arbitrary when the reasons are without sufficient factual basis. The consent of neighboring landowners may not be made a criterion for the issuance or denial of a conditional use permit. The opposition of neighbors is not one of the considerations to be taken into account when determining whether to issue a development permit. Local government must rely on facts and not on mere emotion or local opinion in making such a decision. So this case is 25 years old, but it was cited in the last 5 years again by the Utah Supreme Court. It's good law and the Wadsworth case as well. So these really are the leading guide that we have from the courts on how to determine whether or not a land use decision is supported by substantial evidence in the record. Any parting comments on this issue, Wilf or Jordan?
You know, the only thing I would add is that if really based on the information that was given, like in the case of the police chief, where he said, if they're well managed, well operated, we don't see the crime rate being any higher. That's a great opening for the planning commission to have said, all right, then one of the conditions that we will impose is, and then they could have cited some things that could be done to ensure the management and the operation of the facility, that it's well done and thereby not contributing to the detrimental impacts of the neighborhood. That would be a proper way to handle this. There you're basing your decision on evidence, not on public clamor.
Super, thanks. Okay, so we're at a pivot point again. So remember, we were talking about the broad discretion that is available for legislative acts. And then you'll notice we took a 180-degree pivot. And now we're saying, okay, these are no longer policy decisions. When an application is filed, we're simply administrating the policy that has already been approved. And when there are issues of fact that come up in an administrative review, then we rely on evidence to determine what the facts are. The other thing, of course, we must rely on is the law. So it's important to remember that there are legal restrictions on what we can and can't do. Let me tell another story here. Uinta Mountain Residential Treatment Centers. By the way, I apologize for the photo. What it shows is that Google Earth takes pictures in the summer and in the winter, and they merged this one. But there's an area highlighted here that was a 5-acre parcel where a group home was proposed for troubled youth. And the Uinta Mountain Residential Treatment Centers applied to Duchesne County for approval of this treatment center. And the county planning commission heard this as the land use authority. And one of the reasons I like to tell this story is they did a great job. The Court of Appeals actually said, great, in more or less words, good job, and upheld what the planning commission did. What the planning commission did is they granted the conditional use and they imposed conditions. Like they said, okay, you've got to have a 6-foot fence, you've got to have an alarm system, you're limited to 10 boys because you've shown a picture of the building on the premises and how you can fit 10 boys in there, but we're not allowing you to do more than 10 because that's what you've shown us. And that's the evidence in front of us, is this is the way the house is drawn and this is the number of boys that can be there. And other conditions were imposed as well. So both the applicant and the neighbors appealed this to the Duchesne County Commission. The county commission hears it again and denies it. Remember, it had been approved by the planning commission, and the Court of Appeals was not kind to the Duchesne County Commission. This is what they said. This picture comes into play when we talk about the second issue the Court of Appeals raised. The county's conditional use permit denial based on economic viability was invalid because the applicable criteria in the county code did not include a test for economic viability. So number one, remember, the question is, does the application comply with the ordinance? And the county commission heard the applicant say, well, I can't make it if I don't have 16 boys. That's my break-even point, or that's when it's economically viable. And the county commission on their record said, well, we don't have to improve something that's not viable, so you're denied. The problem with that is it wasn't a criteria in the ordinance. And the question is, does it comply with the ordinance? The other, and the reason for the picture I just showed you with the 2 red squares, the county's decision to grant a similar permit in 1997 was used to show the current denial was arbitrary. They had approved it, a larger facility in a similar location, And they disapproved this one. So it appeared to the court that the ordinance had not been uniformly applied. It hadn't been evenly interpreted. So this is our bridge to the next level of discussion, which is how do we interpret the ordinance? Jordan, would you take a minute and talk about basically how we're supposed to interpret land use ordinances?
You bet. So you see up there, we call it the plain language rule. And essentially what it says is that when you're reading an ordinance, you read it according to its plain meaning. A lot of times you'll hear people, especially those who may have been involved in writing an ordinance, say, well, this is what we intended the ordinance to mean, or this was the purpose of the ordinance. And when you're talking about land use regulations, the courts typically don't go that far to look and consider what the people who were writing or drafting the ordinance said. They say you look at the plain language and you interpret it according to its plain meaning. And if the meaning is clear, then that's the interpretation you go with. In cases where ambiguity arises, or in other words, in cases where two people might read an ordinance and reasonably draw different conclusions, there's a rule in Utah related to land use that says you interpret it in favor of the property owner's desired use. Sometimes interpretation favors the drafter. Often it's interpreted against the drafter. There's a lot of different rules that apply in different cases, but in land use, when you're talking about ambiguity, the important thing to note is if the language is not plain, then you interpret in favor of the property owner's desired use. So you start with the plain language. If that's clear, you go with it. If it's not plain, then any ambiguity you resolve in favor of the property owner's desired use.
Great, thank you. So this is the court, the Supreme Court, 2015. The best evidence of the ordinance's intent is the plain language of the ordinance itself, like Jordan said. We presume that the city council was deliberate in its choice of words and used each term advisedly and in accordance with its plain, ordinary meaning. Where an ordinance's language is unambiguous and provides a workable result, we need not resort to other interpretive tools and our analysis ends. So remember, broad discretion to local government to create the ordinance, but once it's created, then the only question with an administrative arena is, does this application comply with the ordinance? Not what we thought we meant, not what we wish it meant, not what we're certainly going to amend it to say, but what it says right now. Does it comply? And that's the issue before us. Let's talk for a minute about non-conforming uses, and then we'll tell you a case study about this. So a non-conforming use, we call them grandfathered. It was legal when it was established. So when this use started way back before civilization, nobody had a zoning ordinance against it. Or it was started when the ordinance was in a different form. But now we changed the ordinance, so now it's not legal. But, and this is constitutional law, this is a vested property right subject to a taking if we try to interfere. But if it's been maintained continuously without a year of abandonment, then it's a vested right. It's a vested use. It gets to stay. Now, there are some exceptions to that, but this is the general rule, and it sets the stage for our story. So what we have is a auto salvage yard. It's called, ironically, Backyard Auto. And West Valley said, well, not in our backyard. So they, West Jordan, I'm sorry, I got West Jordan on the mind here. West Valley begins to enforce the rules against Backyard Auto. And they say, yes, you were grandfathered. We certainly aren't allowing this kind of a facility in the area anymore. This is the area out by the Rocky Mountain Raceway, by the way, which I'm sure is upgraded from the time this photo was taken. But West Valley says, we're now cleaning up the area, trying to improve it, and you have abandoned your use because you haven't sold parts. You haven't disassembled cars and sold them for a year. So this gets to the Court of Appeals, and in order to make this a little more interesting, a little less formal, let me just kind of give you in a conversational form what all the briefing and pleadings illustrated it was the point here. So if this was just an informal conversation, the court might have said, so why are we here? And the city said, well, these guys have abandoned their use. Our definition of a junkyard use is auto salvage, is basically to keep or store or sell or disassemble auto parts, old cars and auto parts. And the court said, okay, property owner, the city's saying you haven't sold parts for a while, so how is your use preserved? And the property owner said, well, but read the ordinance again. It says to keep or store or sell or disassemble, not to keep and store and sell and disassemble. And the court said exactly right. The court held for the property owner because of the word or instead of the word and. 1 2-letter word. And that's what we mean by the fact that these ordinances are going to be interpreted in, as they're written, not as they're intended. Now, obviously, the city could change the wording and then, see how it goes. But his original right to keep those old cars on that property, because it was a defined use in the ordinance when he started it, is going to be able to keep doing it until he doesn't keep or store cars on the property anymore. Any comments from Jordan or Wilf on that case?
Just, I would just add this. I mean, it's pretty clear when you look at a word like and or. This provision sometimes gets a little bit more vague when you have language that kind of lets you say, well, it could have been either or. Let me give you an example. A lot of conditional use permits or use ordinances used to have a provision in it that said it has to comply with the character of the neighborhood. But what the heck does that mean? And so the applicant says, well, I'm doing that. I'm making it this color. I'm adding this architectural feature. I'm doing this to it. And the city says, well, not so much, but you need to make it a different color. You need to add a little bit more of that. And you need to do something over here that's a little bit different. Well, who prevails in that particular situation? And what the language of the code now says is that we favor the property owner. So somebody that's independent, neutral, can look at it and say, well, I can see where what the applicant says would comply with the neighborhood character. I can also see where what the city is asking them to do would help it to comply with the character of the neighborhood. If it's kind of an equal situation like that, it could be an either or. What the code language and the court cases say now is that we go with the property owner. We allow the property owner to do what they want to do because the language hasn't been clear and specific enough to restrict what the owner can do.
Okay, thanks. So let's talk about that for a minute. This is Sandy, beautiful area. This is the neighborhood we're talking about. Uniformly, completely developed with single family residences. And I'm sure a very lovely place to live. So the problem we have is the house identified with the yellow arrow there. This is Steve Brown's house. And Steve Brown has a different view of what to do. He doesn't live there. And in a time before, it might even date back earlier than Airbnb. I don't know. This is 1998, something like that, 99. Steve Brown and some friends have created what they call the Sandy Ski House website. And people from California, families, can go onto the website and reserve a night or 2 or 3 in Steve Brown's house in Sandy. And they can run up to Alta or Snowbird or Brighton or somewhere and then come back and stay in this house. And the neighbors are not amused. They don't like this a bit. And I can imagine, they didn't like the beer cans in the driveway. I'm making this up, by the way, just for entertainment purposes. The neighbors didn't like it. We know that for sure. One of the things might have happened, they couldn't get the teenagers up on Sunday morning because they'd been too busy watching what was going on in Steve Brown's hot tub overnight. I made that off the record comment to a group last week, and they said, well, they can't be skiers, they must be snowboarders. I thought, well, okay, whatever you say, we're just making this up anyway. But the real story of the case is not made up. This is on page 182 of our land use handbook. Again, we'll make this into a conversation. So the Supreme Court, the Court of Appeals says to the city, what's going on here? And the city says to the court, Steve Brown is violating the local rules. He's running a business in a residential area. He's got a motel going there. And the court said, okay, what does it say in the code that you can't have this use there? And this is what the city read. A residential environment that's characterized by moderate densities, a minimum of vehicular traffic, and quiet residential neighborhoods favorable for family life. That's the purpose of this zone. They said, see, you can't rent your house overnight. The court said, I'm sorry, we're sorry, but that isn't clear. That isn't, that doesn't say you can't rent your house overnight. And the city said, okay, how about this one? No building or part thereof or other structure shall be erected, altered, or added to or enlarged, nor shall any land, building, structure, or premises be used, designated, or intended to be used for any purpose or in any manner other than that is included among the uses hereinafter listed as permitted or conditional uses in the district in which such building, land, or premises are located. Now, I know that's a heavily lawyered paragraph, but what the city says is, we don't specifically allow it, then you can't do it. And the court said, well, but what's he doing? He's renting his house to families. Do you not allow people to rent to families in the zone? And the city may have responded by saying, well, yeah, we have people who rent their houses for a year or 3 years, or, Court says, well, then you allow renting houses in the neighborhood. And the city said, well, that's not exactly what he's doing. He's renting it overnight. Now, what the court would say is, look, if you want to regulate renting overnight, you can do it, but the ordinance doesn't say that now. So he's just renting to families, just like everyone else in the neighborhood that rents their house to families. And then the court made this statement, which is quite a prominent statement in our Utah law. And it's found in the ground rules on page 176. As well as the other standards for defining how to interpret ordinances there in the land use handbook. This is the statement: because zoning ordinances are in derogation of a property owner's common law right to unrestricted use of his or her property, provisions therein restricting property uses should be strictly construed, and provisions permitting property uses should be liberally construed in favor of the property owner. So this is basically the guideline. We read the clear intent, and if there is ambiguity, then we're going to allow the property owner to the continued use of the property, because that's what the ordinances are to be interpreted to read. Now, again, going back to the big overview we started with, lots of discretion to create the ordinances, more limited discretion in interpreting the ordinances. The city can write anything it wishes in the code within, the realms of what's reasonably debatable. But once the city's written the code, it's construed against the city. And that's actually a pretty typical principle of contract law. So let's talk about, once the ordinances are in place there, whether, who has to follow them. This is an aerial view of some subdivision areas outside in Springville, just by Hobble Creek Canyon. And you obviously can see the foothills of the Wasatch there on the upper right-hand corner. And then this is bench property and subdivisions built there. And the neighbors in the area did not want the subdivision built. So they even created their own separate entity. They called it Springville Citizens for a Better Community versus the City of Springville. And this gets to the Utah Supreme Court. Again, not that typical for the court to take a regular run-of-the-mill land use dispute, but they had a point to make with this one. So I'll tell the story as if it were a conversation. So the court says, why are we here? And the Springville citizens say, well, the city hasn't followed its own ordinances, and we want to insist they follow their own ordinances. And the court says, okay, what happened? The citizens say, well, they have rules on how they approve subdivision, and they didn't follow them. For example, there's a rule that if there's a canal on the property where the subdivision plat is drawn, you have to have the canal company sign the plat, saying that the the canal's drawn correctly. And if you attach conditions to a plat approval, they have to be reviewed by the planning commission. And in this case, the city conducted like 7 different hearings. And in the final hearing, the city council attached new conditions that the planning commission hadn't reviewed. So there you have it. The subdivision's got to be thrown out, your honors, and the city just isn't following their own rules. So imagine, if you would, then the court turns to the other party, to the city, and says, well, are you following your rules? And the attorney for the city would have said, sure, substantially. I mean, it's substantial compliance, your honors. You can't be that nitpicky. There's nothing here that really is that big a deal. And by the way, we've provided to the trial court, here's a letter from the canal company saying everything was drawn correctly. And here's the minutes of a planning commission meeting where they said those last 3 commissions are just fine. So your honors, we're just wasting our time here. These guys are being way too nitpicky. And then the court may have turned back to well, this is what the court said. Municipal authorities are bound by the terms and standards of applicable zoning ordinances and are not at liberty to make land use decisions in derogation thereof. This is the standard. This is the gold chip rule. And what the courts may have said, if they were doing it informally, is, city, does your ordinance require those actions? Yes, the city might say. Well, the court said, then you have to do them. And the city may have protested and said, well, they seem a little nitpicky. And the court might have said, well, who wrote them in there? In other words, if you didn't want to be nitpicked, then don't write nitpicky rules in your ordinance. What does the word shall mean to you anyway? The city said, we shall get the canal company's signature, and you didn't do it. So, you've got to do it. You made the rules. We're just enforcing them. And then, lest the citizens get all excited about their victory, the court turns to the citizens and creates another very significant rule. And that is the court saying to the citizens, okay, what difference does it make to you? And the citizens say, well, we don't want the subdivision. The court said, no, what difference does it make to you that the canal company didn't sign the plat? Well, not really much. And the court said, well, get out of here. What they said is the citizens don't have a chance, don't have standing is the right word, to challenge a land use decision unless they are personally prejudiced, unless somehow they are what the state statute calls an affected entity, that they really are, they have been damaged somehow personally, that they have more than the general public, they have somehow been deprived of some interest in their property or some personal value, something that gives them special standing. Otherwise, all the land use decisions would be challenged all the time. So there has to be unique prejudice to a property owner before they can show up in court. Other comments, Will, for Jordan?
It just goes back, I guess, again to this idea that property rights are important. The courts are not saying that cities can't make rules, they can't do zoning and restrict what the property owners can do with their property. They're just saying that you have to be very clear about what it is that you're intending to do, and we're going to hold you to what the language says and not allow you to be kind of interpret it broader than what the language itself actually says. We're going to hold you right to what the language says.
Great. Jordan, do you want to talk any more about standing and how you decide as an ombudsman whether a person has the right to challenge a land use decision?
That sometimes comes up when we do advisory opinions. One of the roles that we play is at the administrative level, we provide dispute resolution services, and one of the tools we provide is an advisory opinion. And admittedly, the standard that courts apply to standing is different than the standard that we apply when people would like an advisory opinion. But it's broader for an advisory opinion, the way we look at it and the way we've interpreted it. But essentially, it's along the same lines that it needs to be someone, presumably for practical reasons, a close neighbor, someone who's going to be directly impacted by the decision beyond what any typical resident of the city would experience. So,
Okay, thanks. Well, so let's talk about somebody who was more than the typical resident affected by a decision. This is Salt Lake County. I apologize for the black and white photo. If it were color, it would be splendid, because this is an area of a little while ago before Salt Lake County was fully developed. And this is kind of a lovely neighborhood where people enjoyed kind of a rural feeling. This is kind of in the center of the county. In fact, this roadway that you see running diagonally through the center is 72nd South Street, at least as it was designated at the time, and very rural. Let me show you another picture of the same view a couple of years later. So in this view, you see the same houses in the center of the photograph, but you've got Walmart on the right, Bed Bath & Beyond, Mr. Mac, and Ross Dress for Less have been built there. And what happened is that the family of a Mr. Croxford, he lived there in the center house there in the red, and he was in his 90s at the time, as our story unfolds. And the city came to the family and said, the county, excuse me, and said, we'd like to build this shopping center. And it's a wonderful thing. It's just going to be great for everybody. And I'm just embellishing the story. The Croxford family said, it not really that good for us, and we're not going to move our father out of his house where he's lived for all these years. And the county had no eminent domain authority. So they basically told the developer, look, you can go ahead and build, but you're just going to have to make your adjustment and build around these people because they're hard to deal with. So that's what they did. The developer built the shopping center around the Croxford property. And this is how you get to the Croxford property. You come here, here's the street sign, North Union Avenue, 72nd South and 1070 East. And then you turn a right-hand turn and you get to where I'm standing when I took this photograph. So the county has allowed the developer to build the back wall of the building down the center of what used to be a county street. And then you make a 90-degree turn, and that's how you get to the Croxford property. And if I were to step back another step, as I'm taking the picture, I would have fallen into the Walmart trash bin. So the issue then, of course, is, well, what's the problem? Let's do it as a conversation. And again, before the Utah Supreme Court, which heard the case 3 times. So the first time was about jurisdiction and whether or not these guys had the right to be in court. And they certainly had a special peculiar interest in how this development was proceeded. The second was on the merits, whether the shopping center or the county had complied with its own ordinances. And then third time was legal fees, which we'll get to that in a minute. So anyway, here's the conversation as it, all the briefing reduced to a conversation. So what's going on here, says the court, and the Culbertson is one of the daughters, and her attorney says, well, the county is not complying with its own ordinances. The county road rules say that a county street has to be 50 feet wide. And if you have a dead end, it has to end in a cul-de-sac. And this is what the radius has to be. And by the way, the shopping center is a conditional use permit. And one of the conditions is everywhere it abuts a local street, it has to have a 20-foot setback, and it has to be landscaped. So all we want is for our 50-foot wide street and then a 20-foot buffer between the back of the shopping center. That's what the county ordinances provide for us. And the court may have turned to the developer in the county and said, well, what's the story? And the county said, well, that's really not a street. We closed it. And the court said, well, okay, we're reading the ordinances. You've got public streets and private streets. We don't see a definition for closed streets. And the court said, is it private? Does the Culbertson family own this? And the county said, no, it's owned by the county. And the court said, then it's a county it's a county street. And then the court said basically this: where the encroachment's deliberate and constitutes a willful and intentional taking of another's land, equity may require its restoration without regard for the relative inconveniences or hardships which may result from its removal. In other words, tear the buildings down. On the record before us, the uncontested facts support only one conclusion: that Hermes acted willfully and deliberately when it constructed its buildings after plaintiffs put both Hermes and the county on notice that the proposed construction would violate county ordinances. By allowing Hermes to proceed, the county stepped into the quagmire which we condemned in Springville Citizens, where we emphasize that local zoning ordinances are bound by the same terms and standards of applicable zoning ordinances and are not at liberty to make land use decisions in derogation thereof, period. So this is the drawing in the Deseret News of what would have had to have happened after this decision. They wanted 1070 East and 72nd South widened to 50 feet. They wanted the 20-foot buffer area, and they wanted a cul-de-sac to be built. Now the green area there says Mybus property because Ms. Culbertson has a sister named Mybus, and they are Mr. Croxford's daughters. But this is the decision that was made. And the last time the case went to the Supreme Court, they ordered hundreds of thousands of dollars of legal fees be paid to the family by the county because the violation of the ordinance was so aggravated. The attorney for the family was Ron Russell, who was at the time the mayor of Centerville. And so we find ourselves in different contexts in this, but this is not something to be goofed around about. People, we create the ordinances to protect everyone, and we all need to follow them. As far as how it stands now, my assumption, I'm just guessing here, Mr. Croxford must have passed away or no longer lives there. The property's gone. The shopping center did not have to tear the buildings down. They reached some kind of a settlement. My impression is that I don't know how many zeros were on that check that were written to the property owners to make this issue go away. But these are serious things that we all need to be aware of as we consider how to apply land use ordinances. More comments on this issue, Jordan?
Yeah, this really just puts a period on the principle that you've been illustrating up to this point, that local governments at the legislative stage have a lot of discretion to change the rules and to craft the rules to create a good community and a community that people are going to be proud of. So once they put those rules in place, those rules apply to everyone. They apply to the property owners, they apply to the developers, they apply to neighbors, and they especially apply to the city who made those rules. So and like I say, this emphasizes that point with the result in mind. So.
Thank you. Wilf, any thoughts?
No, well, it just really goes to the principle again of once you've set your rules, follow them. You really do have to follow them. And the presumption will be made in favor of the property owner in making sure that you follow those rules.
Okay, thank you. Well, so anyway, this is the last in our series of discussion about legislative discretion, administrative discretion, who writes the rules, how do we follow the rules, what are the facts, what are the ordinances, and how do we comply with them? And I hope that's been engaging and interesting. We have a couple of more topics we'd like to consider. We'd like to talk about a unique administrative role when we impose conditions on development. This is an interesting issue, and it comprises a plurality of the questions that come to the ombudsman for advisory opinions, if I've got my facts correct. And then we want to talk a little bit about the appeal process, but let's talk for a minute about conditions on development. You want to start us out here, Jordan, and explain what appropriate conditions are on development?
You bet. So whenever someone brings in an application for development, that development is inevitably going to carry impacts on the community and the community's ability to provide services to that development proposal. When a commercial development, residential development, industrial development, manufacturing, when all of those uses need services from the city. They need roads so you can access the development. You need sewer and water to provide basic services, telecommunication, all the services that give us our quality of life. And what the law says essentially is that when development comes in and they need to be provided those services, then the local government, when they're approving that development, can impose conditions. They can impose what we call exactions. So essentially, they can require the developer, the property owner, to construct those facilities and that infrastructure and those services that the development will need to function. And those services are dedicated over to the city, and the city owns them. So the question comes up is, well, if they're requiring the developer to build and construct those services and then turn them over to the city, does that become a taking of private property without compensation? And the courts have answered those questions, and Craig is going to kind of walk through the cases and how that developed. But essentially, you can see here that what it comes down to is it's not a taking, and it's an appropriate exaction, an appropriate condition on development if it's within the local government's authority to impose, if it's within their purview to regulate and condition. And then also it has to be proportionate to the impact of the development. In other words, the impacts that are created, the local government can require the developer to offset the development's impacts, but it does become a taking if they require them to offset more than their own impacts. So to the extent that conditions require a developer to build public infrastructure that offsets the impact of that development, it's appropriate and it's lawful. When the local government starts requiring a development to offset impacts beyond its own, then you start getting into the realm of concern for constitutional takings law.
Thank you. So this is bottom line, what Jordan just explained. Number one, do we have the authority to impose this requirement? Again, an applicant that complies with the ordinance is entitled to approval. And if we get the idea that we need to impose a condition on them, we can only do it if the ordinance allows for that condition. Two, does it address some burden imposed on the community by the development? Now, this is constitutional law, and so this trumps the local ordinance. So if the local ordinance is imposing a burden on this property owner that doesn't offset a burden the property owner is imposing on the community, the ordinance may be invalid as applied to this property owner. Three, is the burden imposed on the development roughly equivalent to the burden the development imposes on the community? So that's basically the drill to go through to test if a condition is appropriate. So this is a story out of Santa Barbara, California. The Nolan family wanted to tear down this little bungalow and build a beach house, which they did. You can see the picture of it there. And the California Coastal Commission is one of the reviewing authorities for a building permit if the property's on the coast. So the Nolans go to the Coastal Commission. The Coastal Commission says, give us the beach. Nolan said, what? And they said, well, 53 times before you, people will come and ask us for building permit approval, and we always give it, but you need to give the public the access to go across your beach. And Nolan says, I'm not doing anything to impact the public. I'm just building a house in the same place where a house was. I'm not changing anything on the beach. And the Coastal Commission said, excuse us, but we're the Coastal Commission and you can't build your house without our approval. And this is what we're telling you you have to do. Now, this has to do with unique California law. Let's assume for a minute that this place that's wet there on this photograph is the high water mark at high tide. if you're a member of the California, anyone, you and I could go there. In fact, it might be better than being in Utah in the winter. But if you go there and you really get your feet wet, you can walk along the beach. That's public land. But above the high tide mark, that's private. And the Nolans then can restrict the use of it. And the Coastal Commission has just simply trying to extend the public right up to the seawall by demanding that access right for the public every time someone comes in for a building permit. Well, the United States Supreme Court was not happy with this. And Justice Anton Scalia wrote the opinion that said, the local government cannot just solve public problems by imposing burdens on private applications. So number one, there has to be a connection between some authority granted the entity and the condition that's imposed. In this case, the California Coastal Commission had no right, no legislative authority from its charter to improve access along the beach. It also, of course, was trying to solve a problem that Nolan didn't create. The next case is out of Tigard, Oregon. Florence Dolan owns the little store on the upper left-hand corner on the screen here, and she wants to expand it. This is a picture of the store that was built there. And the city of Tigard said, okay, Florence, that sounds a great idea. That's fine. Behind the store, you have this creek. Would you give us the creek? And Florence may have said, again, conversationally, well, I read the Nolan case, and I don't have to give you the creek. And the city of Tigard may have said, no, this is different. Your stormwater from that huge roof and your parking lot is going to go into the creek. So basically, we need the creek to manage your stormwater. And Florence said, okay, but she didn't say okay, but she said, well, what about the bike path? You're also making me build a bike path. And the city may have said, well, look, we have you have this uniform transportation plan, and it has trails, and it has roads and streets and bicycle trails. It has rail. All this is integrated. And so if we can get some people riding bicycles, maybe they won't be driving trucks, and there'll be room for people to take toilets home from your store on trucks, even though people normally don't take toilets home on bicycles. So the United States Supreme Court said, okay, we're willing to bite, but you have to do some analysis. So the duty's on the local government to show that this burden imposed on, in this case, Florence, is roughly proportionate, or as Utah Supreme Court calls it, roughly equivalent to the burden she's imposing on the city. By the way, this is the plaque in the sidewalk that was put to honor John and Florence Dolan for their success before the United States Supreme Court. I was interested when I was there to see that permanent marker on this property. I think it's interesting that these landmark cases are done on very nice coastal properties, and I need to go to Santa Barbara to take better pictures so you can enjoy that one as much as you did the Dolan story. Anyway, these are the appropriate conditions on development. So do we have the authority? Does it address a burden created by the development, and is it roughly equivalent? So that's the steps we go through. One more story. This is BAM development versus Salt Lake County. This is 35th South Street out toward Magna. And BAM development wants to build a subdivision. This is actually, the development went ahead while they were arguing and went to the Supreme Court of Utah 3 times. But it's a 43 lot subdivision, 44. And the red strip across the top of this screen shows the amount of property that was required as a donation to the city, county, excuse me, if the subdivision was going to be approved. And also, the subdivider had to move the power lines, build new curb gutter and sidewalk, and put in this decorative fence. And this was all a legislative requirement in the Salt Lake County Code. If you're on an arterial highway, then you need to widen it to give the right of way and widen it to allow the arterial use. Well, BAM development says, wait a minute, we're not creating the need for an arterial highway. 43 houses don't require an arterial highway. So this is an illegal exaction. It's disproportionate. And the Utah Supreme Court decided in this case, okay, we're going to boil it down to numbers. And this really is an amount of calculation. So what the court said is it's the duty of the county to do an analysis and determine what burden the developer is imposing. So the city hired a traffic engineer who surveyed the cost of roads and transportation facilities in the valley. And then they divided that by the number of households in the valley to figure out what the share of a single home is. And they came up with about $88,000. Said, okay, 44 lots, $8,000 sounds like, $350,000 would be the share that BAM has to pay for. And again, conversationally, the court may have said, okay, BAM, your share, it looks like, is $350,000. That's based on substantial evidence in the record. So how much did it cost you to do this? And BAM said, oh, a couple $100,000. And the court said, you got off easy. Next case, please. So it's an analysis, it's rough proportionality. And we have, of all the issues that we have that deal with property rights, this one really has about as much specificity in the law as we can get. And the important things to remember are just fairness, equity, rough equivalence, and the burdens on the government to take the first step to show that things are fair. And that makes sense. With impact fees, for example, people don't come and start proposing what impact fees they'll pay. Government entities do it. A reasoned analysis. They do a capital facilities plan, now called an impact fee facilities plan, and they do an analysis that shows what the fair share of each portion of development is, and that's how the fees are imposed. So this is, you'd think this is fairly well settled, but often misunderstood on both sides of the building permit counter. Any other thoughts you'd like to offer, Jordan, on this, or thoughts, Wilf?
I'll just say from a practical standpoint, again, like you mentioned, Craig, this question is one that regularly comes to our office. And I think part of the reason for that is that, property owners, developers, and the city or the county, the government and property owners, when they're trying to figure out what is an appropriate exaction, they don't have the luxury of the BAM case where they had experts involved and they put a lot of money toward the analysis and the research. And so they're asking questions of, well, hey, can the city require me to build this road? Can the city require me to widen this road? And it always typically comes up with relation to what we call system improvements, or roads and facilities that benefit not only the developer but the broader community. And as a practical rule, when people are in those situations and they're negotiating with the city, what we say is, and again, this is simplifying it some, but I think if you initially ask the question of, well, does the development need this service in order to operate? And if you're kind of in that realm, then hopefully the city and the developer will be able to come to a solution together that is acceptable to both sides and within the bounds that the law sets. And if it's not, that doesn't mean that it's not the appropriate time to build that facility. It just means that the city is going to need to contribute to some of the cost for that facility. So,
yeah. Any idea, Wilf? What do you do, Wilf, if you've got a development that needs a 4-inch line and the city's general plan shows an 8-inch line out there to serve that part of town?
Yeah, I mean, this all applies as well to, you decide what you need overall for the city once it grows out. And really the state code requires that cities do that in what's called a capital facilities plan. And then rather than make a developer, put in an 8-inch line when they only need like maybe a 4-inch line for their own development, or, they don't need to widen a road to the full 50 feet for just their or the full 66 feet or whatever it is for just their development, but they certainly do contribute to that. A way to deal with that a lot of times is to do impact fees. And impact fees still have to follow these same rules, and the cities have to do the calculations, but it makes it a little bit simpler in order to just say, pay us the fee. And then when we have collected enough fees and we get to the point where we need it, then the city will go and put in those improvements and do them at the appropriate time. It's kind of a balancing and a back and forth act with applicants. So of course, then the argument becomes, well, are you charging me too much for that impact fee? And you kind of have to go through and demonstrate how you're calculating what you're calculating. But it all applies. And in the end, you really still have to follow this rule about that it's directly related to an impact you're having and that you're being assessed at a proportionate basis for that impact.
Thanks. So anyway, that's kind of our discussion about development exactions. Maybe one more example just to show how it, you know, in a ridiculous extreme. This is a 40-acre parcel in a southern Utah community. And when the property owner went to the city, he said, my mother lives in the old house here and we'd like to divide the lot. You don't allow us to build 2 houses even on a 40-acre lot. So we need to divide the lot so we can build a second home. And we'll, you know, there'll be the average between the 2 lots is 20 acres. And the city said, okay, that certainly complies with our minimum lot size. We're in great shape. And they gave the developer, the lot splitter, something to sign with this attached. And the property owner said, well, what's that? The dotted lines around the land. And the city said, well, that represents a 33-foot wide right-of-way that you're deeding to the city in return for your getting the right to split your lot. And I was the ombudsman at the time, Jordan's predecessor before Jordan's predecessor. And the property owner called me and said, do I have to give them the land? And I said, well, let me see the agreement. The agreement not only provided he was to give them the land, it provided that if the neighbors developed into subdivisions, he was responsible to pay his half of the cost to develop the streets that would go on that land. And I said, no, you know, that you do not have to do that. That is clearly disproportionate. You're not creating the need for any of that. And I went to the city and said, I don't understand. And the city said, we were just asking, we won't make him do that. And, you know, that really puts the landowner, in this case, the citizen, got a real bad taste in his mouth. He really didn't think it was fair to even be asked to do that kind of thing by government authority that had control over the total use of his property. So in these cases, we just need to, you know, to exercise fairness and evenness in how we administer the rules. So basically, these are the rules again. Do we have the authority to impose this requirement? Does it address some burden that the development is creating? And is it roughly proportionate? So we beat that one to death. Thank you. Okay, administrative land use decisions are upheld if they're supported by substantial evidence in the record and they are legal. They comply with the local ordinances and state rules. So, So what do? Well, an applicant comes in, provides a complete application, pays the fee, then demonstrates that the application complies with the ordinance legally and factually. The burden's on the applicant, by the way. I mean, we talk a lot about, you know, cities and occasionally when cities or counties misstep, but we don't want to paint this wrongly, that the applicant bears the burden to show that the ordinance or the application complies with the ordinance and that he's met the factual standards, he or she. If denied, however, then it's appealed to the land use authorities. We can appeal the land use authority's decision to the appeal authority or ask the appeal authority for a variance. But you have to exhaust this local remedy, and exhaustion is the right word because that's what happens, we get exhausted. But there has to be a step between the land use decision, legislative land use decision, strike that word, the administrative land use decision and the trial court. You have to go through a local appeal process. Wilf, what's an appeal authority?
So as we've talked about, you know, you have the legislative body that makes the legislative decisions, the elected officials, and you have the appeal or the land use authority that makes the administrative decisions. When someone disagrees with an administrative land use decision that's been made by the land use authority, every community is also required to put in place an appeals process and to designate what's called an appeal authority. That's a lot of times in our old zoning codes, that was called the Board of Adjustment. You may have heard that term before. It's not used in the state code any longer. They're now called appeal authorities. It can be a body like that, or it can be an individual. A lot of communities are now hiring hearing officers, someone who has a little bit of legal background and land use training to understand how these types of things work, in order to, if someone says, we don't think you did it right, whether the applicant says, the city, you've wrongly denied my application, or whether a third party, the neighbors, say, we think the city inappropriately granted the authority or the application, it then is supposed to go to this appeal authority. And the appeal authority is supposed to look at the decision that was made, see if that there is evidence to support the decision that was made, and make a ruling on that. And the idea behind this is to do something short of having to go to the courts, which generally will be a lot less expensive and a lot less time consuming, and resolve the issue before it gets to the point where people feel like they have to go to court.
Thank you. But remember, the standards are the same. The appeal authority should decide the same way a judge would decide when the issue came before her. So just one important thing to remember about the process of appeal, and this is drop dead important. You've got to meet the deadline to file the appeal. If the time goes by and the appeal is not filed, the court has no jurisdiction over the matter. It's over, period. Now, the exceptions to that would only be in cases of fraud, or when someone was not, would not normally have notice of the decision. But when a person, for example, finds out about a decision that they otherwise would not have notice about, they still have a short time period during which they must file an appeal. And this is serious stuff. A person might go to the building counter, talk about the appeal, discuss the issue with the city, think they're making progress, and try to work together, and then a couple of, several weeks later find out they just couldn't do it and say, okay, I'm going to have to appeal. The problem is the deadline passed, and it's not told. There's no waiver of the fee of the deadline by anybody. Let me tell you this story about Draper. So on this hillside in Draper, at the time our story unfolds, there's a rule that says if you want to build on one of these lots that has more than a 30-degree slope, you need permission of the Planning Commission. And I think that's about all it said. So somebody comes along and they go to the Planning Commission and say, I want to build on this lot. And the neighbors come and they're upset and they say, don't allow this to happen. And the Planning Commission says no. So whether or not that was an appropriate decision or not is not the point of my story. A while later, some time passes, and either the same or a new property owner comes back to the Planning Commission and says, I want to build this. Now, notice is provided in the Draper Ordinance, and the first time the neighbors came, and the second time they didn't. And I don't know if this is what happened, but the Planning Commission may have said, well, where's the neighbors? And the developer, the owner might have said, well, they're not here. And the Planning Commission might have said, well, I guess if they don't care, we don't care, go ahead and build. Well, there's a 14-day deadline to file an appeal. So more than 14 days goes by before the developer starts digging a hole. And the neighbors see the hole, and they go to the city council and say, we've been snookered, this is not the way it should have been. We didn't have the chance to present to the Planning Commission what we had intended or what we thought. And the city council red tagged the project and put everything on hold. This ends up at the Court of Appeals. And the Court of Appeals says, again, conversationally, well, so how long do you provide for people to appeal? And Draper City may have said 14 days. And the court said, well, it was more than 14 days. And the city said, well, but we think this is different. And the court may have said, how is it different? The city didn't know what the Planning Commission did. I mean, you're the plaintiff here. And the city said, well, no, our Planning Commission made the decision. We just didn't think it was enough time. I'm really just just telling this a story like it might have been. But the bottom line is, this is what the court said. The city picked the time, and the city is bound by the time. Even the city can't appeal after the 14 days has run. So the house was built in this property. So bottom line, you have the right to appeal. And if you don't meet the deadline to file the appeal, you can't go to court. You must exhaust the local remedy before you can go to the court. So if this deadline passes without an appeal filed as the city requires it to the appeal authority, it's simply too late and the issue's behind us. Any comments, Wilf or Jordan, on that issue?
So when I have conversations with people about this issue, sometimes the question comes up, well, why such a harsh result, and why are the time periods so narrow? And the courts, as I understand it, when they've talked about this issue, has framed it as an issue of predictability and certainty. That, you know, there comes the point when you're making land use decisions where a property owner, and it's a balancing, right? They're trying to balance all the interests involved, and the reason in this case, and where the equities kind of lean, I guess you could say, is in favor of the property owner and the decision and predictability, so that people can move forward with their land use decisions. So
thanks. Wilf, what's a variance and when is it appropriate?
So variance comes into play in this case. When you adopt your zoning regulations and your ordinances, you're putting rules in place, and that it'll cover pretty much most of the situations, but it can't cover and account for every possible situation. You're going to have things come up occasionally that your ordinance, the rule that you've put in place, unfairly impacts somebody. A good example, let's say you put into place in your zoning code now, you say, okay, we're going to require now that all new structures built in this zone have to have a 30-foot front yard setback. Well, you've got a property person who's owned some property in that community forever, and in the back of their property is a very steep hillside, practically a cliff. If he puts a 30-foot setback on any structure he tries to build there, he's going to wind up with a 20-foot wide structure, which is pretty impractical. There's hardly anything you can do with something that's that narrow. It's just not a fair rule. That property owner has been impacted really and unfairly by the rule that you have put in place, and not through anything that he did or she did and caused. It was just a circumstance of their property. That's what's called an unnecessary hardship. We've imposed an unnecessary hardship on that person. That person cannot build a house now on that property like everybody else in that zone still can with the 30-foot front yard setback. That's a substantial property right in that zone in order to be able to build a house, which is allowed in that zone. In those kinds of circumstances, a variance may be warranted. A variance is an exception from the rule. It's where you actually say to somebody, well, this rule applies to everybody else, but we'll let you get out of the rule because you have an unnecessary hardship that's due to the circumstances of your property, not something that you want to do that maybe is beyond what everybody else wants to do, or it's something that you did by the way you created and divided that property or something. And it's in order to be able to do something that everybody else in the zone has the right to do. You have to meet all of those requirements that you show up there on the screen in order to be able to be granted a variance. They're rare. They're something that doesn't happen often, but it's like a safety valve.
Great, thank you. So just a quick story about a variance. This is the what was then the Market Street Broiler on 13th East in Salt Lake City, across from the University of Utah, and they needed a variance. This is a historic building. It's a landmark structure according to the Salt Lake City Landmarks Ordinance. It used to be a fire station, and the prominent facade is the east facade, and the second prominent facade is the south. And in the ordinance, it says you can use a historic building for a commercial purpose, even if it's not the underlying zone, so long as, and then it lists some conditions. And one of the conditions is you have to have a 10-foot landscape buffer around the building. Well, this building isn't 10 feet from the property line on the north side. And on the west side, the problem is you can't have a 10-foot landscape buffer and have anywhere to put the trash. So Gastronomy Incorporated goes to Salt Lake City Board of Adjustments and asks for a variance. And the board talks about it and they decide to grant the variance. And Ms. Wells and 9 other property owners sue and challenge it. And the Court of Appeals rules the variance illegally granted. And the reason is, and again, this is the last time you'll hear me sing the song, there wasn't substantial evidence in the record to support it. And they didn't make a finding of all 5 of those decisions. All 5 of those required findings were not on the record. Well, these pictures were taken after the case, and you can see there is in fact a trash enclosure, and that landscaping that's there is not 10 foot wide. But this is what the board had to go through. They had to go through it again, do it over. Let's go through the points. Unnecessary hardship. Is it a hardship for a restaurant owner to put trash container on the front or the south facade of this building? Now, they had to review that as subjective decision. Most of the time, you would not be required to put your trash in the front yard. The city doesn't want the trash in the front yard. The historic nature of the building, screams for those dominant historic prime facades to be preserved without having a trash container in front of them. So they may have evidence provided by very professional and successful restaurant owners that it's not a good idea to put the trash by the entrance. And so they found that it was an unnecessary hardship to require the trash anywhere, or to provide a place, to require the trash to be put somewhere where you would otherwise not be required to put a 10-foot buffer strip in. Clearly, these circumstances are attached to the property. The building was there when gastronomy showed up. It's a historic building. We like it as it is. We don't want it changed. It's not the preference of the property owners. This is driven by where the building is on this small piece of property. Is it a substantial property right? Well, it may make the difference between a successful business and not a successful business. It may have to do, if you tried to put your trash in the front yard, the city would cite you because it's illegal. And so again, other properties in the community don't have to deal with their trash in this manner, and they are not required thus to comply with a rule that seems unfair in this case. Clearly consistent with the public interest to preserve the historic nature of the building, the spirit of the ordinance is preserved, substantial justice is done, go ahead and put your trash on the west side. The second time around, the Board of Adjustment does it correctly and the variance is granted, and gastronomy, it all works fine. Life goes on. So any other thoughts, Wilf or Jordan, on the appeal process or the granting of variances?
Maybe with regards to variance as a kind of a, practical consideration or a practice tip. During the time that I worked as a planner in a city, we'd often have people come in and say, hey, here's my proposal. We'd tell them, oh, unfortunately, you don't comply with the rules, maybe related to setbacks or something like that, and the footprint they want to use for their home. And then the response was, well, can I apply for a variance? But it's a scenario where they just can't do what they want to do, as opposed to they have a specific hardship. And in those cases, all is not lost. Because there is still the political route that you can take. If there's a rule that you think is impractical or maybe too strict in how it's imposed, then you can also apply for an ordinance change. And I've seen people have success going before the elected officials and saying, hey, we think these setbacks are too strict. We think it's in the public interest to change them for everyone in the zoning district. And in those cases where the property owner is persuasive and brings up a good point, I've seen elected officials say, yeah, you're right. We do need to change our rules to allow property owners to have more flexibility with their property. So.
And Jordan makes a great point. It's not not very efficient. It can be done relatively quickly when the timing's right. There just has to be, if we're changing the ordinance, remember, it's a legislative decision. There has to be a public hearing. So we notice a hearing, we go to the planning commission, recommend approval. The planning commission can recommend it to the council, who could handle it very quickly. No public hearing required necessarily. But Jordan's right, you have to pick the forum. And many people get trapped in the variance box thinking that's where the solution lies, because the hearing officer, who isn't elected and sometimes doesn't even live in the community, that hearing officer is not going to substitute her judgment for the political policies set by the city council. And so the proper role would be to go to the council and get it adjusted. And cities should allow for a reasonably efficient way to get that done. Thank you, Jordan. Okay, so that's the appeal authority. I want to introduce one other topic before we wrap up, and that is the issue of ethics and due process. This is a basic fundamental aspect of land use, and it creates issues when property owners are not afforded this, whether they be neighbors or applicants. And just to finish up, I thought it would be good to focus on this for a few minutes. Basically, if a person's entitled to due process, and I want you to interpret this rule somewhat loosely. The courts can be quite strict about this and really draw fine lines. But if a person is given notice of a meeting and entitled to speak at a public hearing, then they should be afforded these courtesies. And in my opinion, the applicant herself should always be afforded these courtesies. And one, notice of every time this application is going to be discussed. For the public, whatever notice is required in the ordinance. For the applicant, every time the application is going to be discussed. And that notice can be, does not need to be provided under state law for administrative decisions generally. It's something the local ordinances provide for. So once we're having the meeting or the hearing where the issue is to be discussed, then the person who we're granting this due process right should be heard, and they should have the ability to present evidence. And sometimes that 2 or 3 minute allocation is just simply not enough. I do not agree generally that you can fairly do that to an applicant. But if you want to limit public comment to a certain extent, then the courts have not forbidden that. It just needs to be reasonable. And the protocols ought to be such that it ends up being easier rather than harder to participate. And then the applicant or someone entitled to due process needs to be able to respond to the evidence presented by others. So you wouldn't say to the applicant, go ahead and state your case, then to the neighbors or others to present their case, and then say, okay, our hearing's over. The applicant needs to respond to the evidence presented by others, and others ought to have a chance to respond to the evidence presented by the applicant. And I'm not saying it has to take forever, and it needs to be managed appropriately so it's fair to everybody, but these are essential processes in our democratic system. And even if we comply with the law, we need to comply with the spirit, because this is the taste in the mouths of the people who leave the hearing. And people are greatly helped. The whole process is helped by the chair of local meetings doing their best to trying to manage these things in a way that it appears fair and open and not heavy-handed and not where the decisions are already made. The last thing is impartial decision maker. The written rules are pretty light here. In Utah, you only have a conflict of interest if you personally have a financial stake in the outcome, or if it's what we call the first degree of relationship, your wife or husband or son or daughter or father or mother. But again, appearances are important here, and we need to do our best to try to respect the opportunity to be heard and to have the decision made fairly. Let me tell you just a quick story. This is a stinking operation. This is the dairy products plant in Wellsville. And they bought it and began to operate it, Dairy Products Services Incorporated. And then over time, their product level changed and they started to create odors that the city and the residents couldn't stand. And this is not the most sophisticated. This is the Wellsville City Hall. And they heard this case, and the Utah Supreme Court congratulated them when it was all over. It wasn't strictly a land use case. They were trying to decide whether or not to revoke a business license. But they heard dairy products. They allowed dairy products to respond to evidence. They allowed dairy products to ask questions of the residents who spoke. And they notified dairy products of all the hearings, and they conducted their meeting openly. And this is a great case to read. We don't have time to get into much of it, but Dairy Products v. Wellsville is a terrific example of how, if somebody wants to challenge bias and due process, even local entities of not great sophistication can meet the requirements of the code and provide due process in a setting that makes it fair to everybody. Other comments on this issue from Jordan or Wilf?
I'd just add, that again, citizens come to the meetings. They generally come to express their opinion. That's fine in the legislative setting. In the administrative, it's a little bit different. There we call it public clamor. In order to help people to understand what's happening and in order to make this process work better and more smoothly, now that you've learned a little bit about this, help everybody else to understand as well what's involved, what the difference is between these kinds of actions and what's appropriate to be said and what is appropriately can be done. A lot of times people, when they come to these administrative hearings and they say their piece and then it gets approved anyway, they go away saying they made their mind up before we even came to this meeting and they never listened to us anyway. Well, that's because the decision makers are somewhat constrained, because if the application meets the requirements in your code, you're compelled to approve it. And helping the people to understand that will just help the process to hopefully be a little bit more credible in everybody's eyes and to work a little better. Okay,
thank you. Well, we've covered the heavy duty topics here, but before we split and end this conversation, I want to just remind you of some terrific resources that are available to people in the state of Utah when they want to better understand land use. So what I want to do first is give Jordan the chance to talk a little bit about the Property Rights Ombudsman.
Yeah, thanks, Craig. So our office, the Office of the Property Rights Ombudsman, like we've talked about, Craig was the first ombudsman in the state. Our office has been around over 20 years, and it's developed, fortunately, thanks to Craig and my other predecessor, Brent Bateman, a good reputation of being a neutral third party in land use and eminent domain disputes. So you can go onto our website, propertyrights.utah.gov. You can see the services we provide. Primarily, we can do advisory opinions in land use when there's a dispute, to help provide a dispute resolution tool that will predict what a court will say about a given situation and a given legal question. We also provide mediation if the parties are interested. And on the eminent domain side, we provide mediation. We can get a property owner an additional appraisal if they feel like what the government is offering does not reflect fair market value. And then a lot of what we do is we provide trainings like this, and we spend time on the phone with people answering questions just to help them better understand the process and hopefully make good decisions in the land use arena. So yeah, if you have any questions or would like to talk to us about something, please give us a call and check out our website. So
this is the website, Utah or propertyrights.utah.gov, and it's a great resource. There are terrific things available there, including, you'll notice up here in the upper right-hand corner in the resources, upper left-hand corner, advisory opinions. So the complete text of every advisory opinion is there. The next resource we want to talk about is Land Use Academy of Utah, and that website is www.luau.utah.gov. And these, of course, are on the same printout of these slides. It's on the Utah Land Use Institute website at the seminars page. But they provide at that website training videos and publications and links to legislative changes. They focus on citizen planners in particular. So this is the very best place to go for someone who's brand new to the Utah land use arena, particularly new planning commission members and newly elected officials. It's hosted by the Utah League of Cities and Towns, and it's a terrific resource. We also have the Land Use Library at utahlanduse.org library. And this is the Utah Land Use Institute's page, funded by the Ombudsman's office through its land use grants, just like this program you're a little tired of enjoying today. But there we provide a database on advisory opinions. So we have about 1,000 different lines of information about 247 advisory opinions. So we have basically on an average, we've mentioned each opinion 4 times for 4 separate issues that are covered in that opinion. And this is a searchable database. So using a find function key, you can look for any keywords you're looking for and find them to determine in this database which advisory opinion might have discussed the issue that's on your mind. And these advisory opinions are not precedent, they don't have legal binding authority, but they are great resources and they show you some terrific research, and they cite the original authorities that you need to be familiar with if you're trying to look particularly from a legal aspect as far as how a judge might rule on your particular issue. We also have topical review of land use regulation topics. Much of the material in the ground rules book is there for you to use to review chapter by chapter. There are detailed summaries, more detailed, legal treatises somewhat, maybe that's too fancy a word, for specific topics. Like we just published an updated view of non-conforming uses, including the latest references to the latest law and to some advisory opinions. We have streaming video of the Utah Land Use Institute Fall Conference. And coming soon, thanks to the Ombudsman grant, we'd like to make our publication, the Utah Law of Eminent Domain, we'd like to update that and make it fully available to the public online for that purposes of understanding better eminent domain law. And certainly not least, we have the Land Use Politics blog. What is your goal with the blog, Wilf?
To make people angry? No. Just to kind of keep people informed on what's happening with land use issues, and really kind of more like the political aspect of it, and where we're at, where we're going with the future of land use in the state of Utah.
Thank you. And Wilf's insights are particularly helpful when the legislature is in session, because there's a lot of stuff flying around on Capitol Hill, and Wilf really dedicates himself. Much easier now that it's so much of it is available live online, monitoring the hearings and then looking at the latest versions of the bills that are passed. But often he'll have access to drafts as soon as the legislators themselves do, and can help us better understand, because of his wealth of experience, how it all fits into the what we've expected in the past and how the land use process is evolving in the future. So it's just a terrific resource. So that said, we talked about the Ombudsman. Remember, the full text of advisory opinions are there. And also there's a place for recent case law updates and more information about eminent domain, the best place to go for that. And that kind of wraps up what we're doing here today, but I do want to give my associates another final chance to wrap up. Jordan, do you have anything to offer in summary?
I don't. Well said. Thanks for having me.
Well, thanks to you, Wilf.
I think I did mine. I did share this knowledge and information, especially with the citizens that come to these meetings, and help them to understand the process, how it works, and what's going on, so that everybody feels a little bit better about what's going on.
And you'd be surprised how much more engaging this whole thing is live and in person.
Yeah.
So Wilf and I and Jordan on some occasions are available to come to your community and present this live and tell even more jokes in a way that you can do when you're not being broadcast to the world. But we again appreciate the Ombudsman grant process from the 1% fee on building permits. We appreciate your attention. You've stuck through to the end, and I hope your practice and your association with the whole land use arena will be enhanced by the process. Thank you very much. That concludes this recording.
Craig, before you sign off,
Sure.
take a look at the chat.